beg Lordship. With the consent of other side, I beg to mention item number 39, Lordship, 2 days late. Lordship, this matter may come after 2 weeks, Lordship. Certain instructions required from my client. 39. Three. Interim order is there, Lordship. Obliged.
What kind of interim order? What kind of interim order?
People from bail, Lordship. Suspension.
In criminal offence for suspension of sentence, 389 application.
But is not disposed of.
It's not disposed of.
Without disposing that there wasn't any interim order.
The interim order.
Interim order was there.
Yeah.
But that we don't need any extension because 389 application till disposal of the appeal.
That's what I say. What kind of interim order? They just take care of it.
39. We don't have the application here.
I 60.
If there is some interim bail order, then it's a different thing.
The interim passed by the Danit court below.
No, Lordship.
What on the side? 56.
I-660.
I-660. 560 is another 43. One 556 was filed. There sort of emergency was there and interim was there.
Acha, medical emergency.
56.
Acha. Then he surrendered.
So, but thereafter you have not said it was
It was extended. It was extended and he is out of station along with his baby girl. That's why.
So in case you are now extending and
Yes, Lordship. That's why.
next week it go for the argument.
Yes. Obliged.
Oh no, yes. Petition decides. Look one,
May it please your Lordship. Lordship, I beg to mention for listing of a bill matter which was left out on 16th of May.
Bail matter is not. Bail matter is before 16.
Okay.
May I please your Lordship? My Lord, petitioner filed an appeal Lordship. In that case, Lordship, the Lordship has granted interim bail basically on medical ground, Lordship. My Lord, accordingly we have done surgery, Lordship. And the period of 2 months, Lordship, granted by your Lordship has already expired. Lordship, we are paying for some more days, Lordship. That's why we filed another application that was listed before the Honorable Justice Lordship Nondi. And
If it comes for us, then
Lordship, I am praying for listing on Monday, Lordship.
it is is already listed before just
No. That was listed yesterday, and this on that honorable court directed to be listed before appropriate bench. That is your lordship, before your lordship. So I am praying on Monday. Obviously.
Yeah, please, your lordship, I beg to mention one criminal revision, my lord, in connection with IA criminal, my lord, for condonation of delay, to be listed on Monday or Tuesday, my lord, next Monday or Tuesday.
revision. We mentioned before senior bench.
Senior bench.
Please, Lordship, I beg to mention item number 9. Lordship, I am appearing on behalf of late Nobi N. Hawk, N. Ahmed. Lordship, the
He is
Yes.
not available today.
is already expired, Lordship.
Who? And Ahmed?
N. Ahmed,
The council?
counsel, in the senior counsel. Appellant
But your
wanted,
name is also here.
my name is not here.
Now who has it engaged?
Lordship, appellant wanted to file another wakalatnama to fresh and new in his counsel. It's just action for today, Lordship. And fixed date after 2 weeks.
You want to start?
Yeah, Alam.
Application. 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 Take it. Well, do you have any information that they have engaged any other?
Lordship, they inform us.
They have engaged or
No, Lordship.
Not yet any.
They inform her before the wife of the late N. Ahmed. And they stated that they are engaged in a new counsel. So they return the file.
and here name of Mr. A. Awal, B. Zain and Ahmed and Mr. R. A. Ahmed.
Lordship.
All are from your district or
Lordship.
they are no longer appearing. They are no longer appearing.
No. Deeply obliged.
I beg to mention item number 10, Lordship, for exonerment. Engage counsel.
Lordship, I am appearing for Esplanade 2. I have objection. They have not informed me. This is an urgent matter. Kindly take up this matter.
What is
One day, Lordship.
No,
engage
Lordship.
counsel.
Kindly, it is an urgent matter.
why
Not
you
well
are
today.
seeking for adjournment?
Engage counsel for the petitioner not well today, Lordship. One day, Lordship.
Who is the counsel?
You doctor.
You doctor.
Can you fix on Friday?
Lordship.
Kindly. It is an urgent matter. So it is against, they are against the maintenance order. They have not paid any maintenance. So his minor daughter also, he is not paying. Kindly fix on Friday.
Friday is the 24th.
May I please, your Lordship. Lordship is 439 bail application. Second time before your Lordship. Earlier rejected Lordship. Lordship will find the order at page 25. Gold. Today Lordship 39 days.
60 days is the limit, okay? Huh? 90. Oh. Then?
B.
89 B.
B to 19.
B to 90 days. 49 B and C.
C to B to
What's it will mean?
B to 90 days.
Oh.
Lordship is actually nothing recovered from the present petition, Lordship.
In your lordship's earlier order, it is written that after perusing the case diary, it was found that he is directly involved with the alleged business of selling fake gold. And during investigation, police also has recovered many photographs of fake gold articles.
That is pertaining the fake gold. The fake currency, Lordship, Poetland B is not attractive.
Fake currency কথা কত
Fake currency বেলেগ কথা পাইছে co-equal
Subsequently added.
subsequently added later on.
Otherwise, FIR speaks of only fake gold
Fake gold.
business.
Earlier fake gold, then subsequently on the
Ah.
player of the IO, before 1890 and 489 is also added.
And that fake currency is required from the co-accused. But as far as this petitioner is concerned, only fake gold. That photograph of fake gold item. Lordship may kindly consider length of detention 39 days. He has
Too
been
less comparing 90 days.
then Lordship
Otherwise, he is 90 days. Fake currency note was seized from
Noor Muhammad Buledar.
Noor Muhammad, House of Noor Muhammad,
Yes,
at page 21.
and he is Lordship Azharul Islam. And Lordship, that no victim was identified. That is one of the Lordship aspect. No victim was identified. Recovery is there, Lordship. But before anyone could be cheated, Lordship, those articles have been recovered. So Lordship 489 B and 420 Lordship cannot be admitted. By humble submission.
এইটো কোন হ'ল আজহাৰুল ইছলাম Azharul Islam is in the FIR. His name is in the FIR, no?
Parnam Tafai Rasim Assess. Nine, nine, nine,
Ground
nine.
is there. Only the length of detention. Otherwise, there is no ground.
Otherwise, FIR also doesn't name him. FIR is against Saiful Hussain and one
Bracket is there.
Qasim. Only during investigation they named him.
But Lordship may kindly consider only one aspect, that only fake gold item have been Lordship. He is associated Lordship. That 489 B will not come. And so far as 420 Lordship, no one has been cheated. No victim could be identified. And Lordship, at this stage, Lordship, he has been thoroughly interrogated Lordship. The IO has got sufficient time, Lordship. 39 days as on today, Lordship. He will cooperate, Lordship.
Otherwise, the papers that he has annexed, I don't find any materials against this person, Azharul. Case diary will make it clear.
Along with some others, there
Some other
it is,
Yes, that's 120 B is
items.
there.
Apart from fake gold, there also there with the business of the fake currency. So in entire area, Fakipur, Big Puja, not Fakipur. They are supposed to cheat or whatever to be some coming from border district or but there are some I don't know. So they were trying to it also. Victim was under victim was not identified because it was not prior to that process it was also that
Recovery only.
Acha.
but
But
in
39
the investigation, it found that they are not only deal with the business of fake gold but
also
they are
currency.
with the fake gold, fake currency.
And lots of Lordship, he is not habitually involved, Lordship. Not shown arrested.
39 days is too less. Lordship can see the case diary if they have made some progress. And
Because that it was like
earlier it
so
was
without further opinion, that maybe
Lordship.
should not
And case diary, Lordship.
case diary be called for. Should it be on Monday or
Lordship. Lakhimpur. I huh?
Monday, Lordship.
Wednesday
One tarikh.
or any day.
On 30, Lordship.
30.
Thursday. Obliged. May I please, Your Lordship?
Sunny do.
Yes.
May I please, Your Lordship? My Lord, second application, Lordship. Earlier rejection order at page 15, Lordship. Page 15. My Lord, allegation under section 354D and 376. 354D is bailable section, Lordship. And there is no ingredients of 376. That was also revealed from the submission of learned PP on the day of hearing, Lordship. My Lord,
Far I can remember, the materials were there, and the fear of your present petitioner, she is not in a position to be able to attend this.
yes, but
So
that
psychosis in the.
that was the allegation in the
ground for it? Is there new ground you have?
Lordship.
Is there any new ground?
Lordship, now that situation is over, Lordship.
How can you say?
That my instruction, he is not following the girl, Lordship, and he has also got a lesson earlier when the bail was rejected. He has got a lesson. Actually, they were tried to solemnize marriage between the victim and the petitioner, Lordship. That was the actual fact, and this approach was from the guardian, Lordship. Victim side rejected, and after rejection, they actually persuaded the matter. Therefore, they lost this FIR, Lordship. Actually, nothing that sort of happened that she could not go to a school, Lordship.
But the case that speak better.
Lordship. FIR statement of the victim also says that there is nothing regarding 376. That was also their, Lordship.
I think she is a minor. She is
No,
going to her
no. She was 18 years 21 days on the day of occurrence,
As
Lordship.
for them, it was 18 years, but as for that
Yes.
was fine.
That situation is over, Lordship. He has also got a lesson till now, Lordship. So my prayer there is that Lordship may kindly come.
Okay, if one reject, once rejected, so already case that.
Lordship.
30, we have given.
30.
Please.
Oblige, Lordship.
Matlab 15, 16, 17, 18, and these are out of same case diary. Dharamtul Malat 15 and 16 BA, 17, 18 are AB. But though earlier CD was there, it was taken by the IO because one requisition came from the session court, but it is not returned by the session court. Matlab, at present,
Whether it is still lying in the second court.
that could also not. I think it's in Morigaon session court.
Morigaon.
Otherwise, these two person 15, 16, behind above 82 days, but they are the mastermind. Matlab mein, that
Dharamtul case.
they are the matlab person. Matlab they are the two are the main master.
We may consider the period of detention later on. Take instruct whether case is ready for charge.
Matlab they supposed to matlab give the CD what on report also. Matlab after some time I'll take instruction from our office.
Both 15, 16,
17, 18, all.
19
separate.
is separate.
May I please, Your Lordship?
16, 17, and 18.
May I please, Your Lordship? My item was item number 9. And somebody has mentioned without informing, I have come for the case and now I have come to know it is adjourned. Without
Item number
consent.
9.
Yes, Your Lordship. Nowadays, frequently it is happening like this. Huh?
They are not
But it is information. আমি তো না জানো এইটুকু কথা। We have come to attend the case.
An Ahmed expired. So his other his junior. Petitioner may approach other advocate.
he already and his other advocates, so they are not available.
মানে করে দিলে হয় আমার।
Inform them.
But in future, Your Lordship also be strict in this way because in many cases I have found no information, just adjourn.
Yeah, when the
Yes, yes.
accountant submits
Yes.
that
This is why.
I have already informed.
Yes, Your Lord. That is okay.
Sometimes
Inform
some
them.
of the advocates barely submit
Yes, Your
and
Lord.
not inform.
Yes, Your
And
Lord.
we pass the order to inform it.
Yes, Your Lord.
Sometimes they should consent.
Yes, Your Lord.
That is for us.
Because we are not aware what happened. Much obliged.
Okay.
My lord, my senior is on leg. Can it be passed over to someone?
Otherwise, I give 90 CD.
Taking time. Wait, don't make solution. May it please your lordship, I think again they are going to take time. Matter is pending since 2019. Each day same prayer is made. My lord, my interim order is to be considered in this case. I'm just placing the facts, my lord, what has happened in this case. I have come here for quashing of the complaint filed by the Enforcement Directorate under PMLA Act. Now, my lord, this petitioner, he is facing a CBI proceeding on the same set of facts, on the same ground, whatever is taken by the Enforcement Directorate. So the investigation conducted by CBI is the ground of the case in the PMLA case also. And besides this, this offence was committed allegedly in 2005. And the PMLA Act came into effect from 2016, I believe. 2002. So it cannot be given a retrospective effect. The date on which the offence is alleged to have been committed, at that point of time, this was not a scheduled offence. Therefore, this the special court cannot take cognizance of the matter because it was not a scheduled offence on the date of commencement of the offence. Therefore, my lord, this ground was also taken in series of these cases of same nature, where the ground has been taken that on the date of offence is committed. This was not.
Case was last. The last order is 2021. Thereafter it is not.
No, my lord. Every day the same prayer. Every day same prayer.
Every day will come later on, but there is after because. In the order dated 22nd of January 2021.
No, my lord, it has not been listed. No, been listed. Now I am facing trial in the special court. Similar cases, my lord, series of cases has been, my lord, stayed by this honourable court, and my lord, a case is also pending in apex court, and this court has held that until and unless the matter before the apex court is settled, the matter should not, my lord, continue. And I'm placing this order, my lord.
Okay, what is your problem?
Lordship, today my senior won't be able to come to the court, Lordship. She has some personal difficulties, Lordship. So any
Standing consider estimate.
no, Lordship, for ED,
The presence of the senior is not required. I think this is covered, my lord. I'm placing this question.
A.
Gayan, Lordship.
A. Gayan.
A Gayan, Lordship. Except today, Lordship, any date, Lordship.
As Gayan also item number 5. It's for Gayan.
Yes.
It is obviously this case.
My lord,
cases are
similar
pending.
order is there, my lord.
And what is submitted already? It can be deposited of it.
Ma'am, Lordship, tomorrow?
Tomorrow is all.
Next week, Lordship.
Friday, my lord.
I think.
There's again the date in the special court is fixed on 2nd of June, my lord.
Can it be on Friday?
Yeah.
Friday? Friday. Try to know if should because the matter of 2018 is within valid. But
Other matters are stayed already, so no point, my lord, that why this matter should not.
Lordship, may please, your Lordship. Lordship, these are the revision filed by CBI challenging the order passed by learned special judge CBI, whereby the application filed by CBI to take the voice sample of the accused was rejected, Lordship. So the item number 6 and item number 7, these are two different cases, Lordship. Facts of the cases are different, accused are different, only the law point involved in both the cases are similar, Lordship.
Can here first item number
6. I am taking item number 6.
But it will be better if both are heard separately.
Law points
Item
are
number
same.
6.
Let us get 6.
Yeah. 6, my lord, can hear, then my lords can come to 7.
Lordship, item number 6, Lordship.
Yes, item number.
Page 23 is the impugn order, Lordship. Sorry, 21. 21, and I am directly referring to the finding of the court below in the impugn order, that is in court, page number 23. 23 of my petition, Lordship. There are 9. On the basis of the aforesaid decision, I am of the considered view that if the voice sample sought by the investigating authority is with regard to intercepted or tapped telephonic communication, then the voice sample can be given only if the intercepted conversation had been duly intercepted as part of prescribed procedure and the principle of law laid down the Honorable Supreme Court as discussed and narrated above. Coming to the fact of this case, I have perused the petition of CBI, the relevant area of this case record, and also relevant portion of the case diary produced before me. The CBI has not been able to place any material before this court to satisfy it that the intercepted telephonic conversation with regard to the voice sample is needed have been duly intercepted in accordance with the aforesaid procedure and the settled principle of law pertaining to telephonic tapping. Further, the circumstances in which the conversation have been intercepted also do not, in my considered view, fall within the ambit of the criteria of the public emergency and interest of public safety as laid down by PSL in context of section 5 of the Telegraph Act. So this is the finding, that CBI failed to place any material evidence before the court, and it has not fulfilled the criteria which is laid down in the Telegraph Act and the guidelines given in the PCL judgment. That is the finding. So before making my submission, I'd like to place before this honorable court, we have filed an additional affidavit in this regard, Lordship, whether there are orders, materials available on the CD or not. If the Lordship peruse the CD, it will reveal that there is a valid order passed by the competent authority with regard to the telephonic interception of the telephonic conversation. I have annexed, the Lordship may kindly have a look into the additional affidavit, the rejoinder we have filed, copy of all the orders passed by the competent authority. Let us now, before going to this, Lordship, let me clarify what is the law involved. What is the law required to intercept the telephonic conversation? The law is very clear under section 5 of the Telegraph Act. Lordship may kindly have a look into the Telegraph Act, section 5.
And you have Telegraph Act.
The only condition precedent is that in case of public emergency and in case of public safety, these are the two condition precedent under which all can be intercepted. That is there in section 5, Lordship. And it is the competent authority, Lordship. And the competent authority has been described under Rule 419A of the rule, which has been framed subsequently after passing of the judgment in the QCL. But QCL judgment has said, discussing all the law relating to, Lordship, safety of the accused petitioner with regard to telephonic conversation, certain guidelines has been framed. Those guidelines will be affected till the framing of the rule. Subsequently, the Parliament has enacted the rule, that is Rule 419. And what 419 says, 419, yes. Competent authority, Lordship, can pass appropriate order in case of public safety and public emergency within a stipulated period. That is drafted in the Rule 419A, Lordship. And accordingly, CBI, while intercepting the telephonic conversation between the accused, obtained those orders. And in pursuance of those orders, Lordship, we have intercepted. That is our stand. And that order is why within the parameter of the law, and that is there in the CD, Lordship. I don't know how the learned trial court
did not take into account those orders of the competent authority, Lordship. I have already enclosed the orders of the competent authority in the additional affidavit. Lordship may kindly have a look into the additional affidavit, Lordship. Page 83 is one of such order passed by the competent authority. From page 83 to 92, these are the orders which were passed by the competent authority. Additional affidavit we have filed, Lordship, annexing all the documents relating to intercepted call, Lordship. Page 83 of the additional affidavit. Rejoinder we have filed, Lordship, by CBI, Lordship. Detail, Lordship.
You think page?
Page number 83 of the rejoinder affidavit. Affidavit in reply of the rejoinder filed by CBI.
Yes, 83.
83 is the order. It starts from 83. 83 is the order by which this is the order passed by the competent authority, that is the secretary, who was empowered under Rule 419A of the Telegraph Act. So this order has been passed. May I read, Lordship? Whereas as per provision in sub-rule 1 of Rule 419A of the Indian Telegraph Rule, notified on 28/1/2014 as Indian Telegraph Rules, framed in exercise of power conferred by Section 5 of the Indian Telegraph Act, the Secretary, Ministry of Home Affairs, Government of India, has been authorized to exercise power of the central government under subsection 2 of the Section 5 of Indian Telegraph Act. Now, therefore, I, Union Home Secretary, being satisfied that for reasons of public safety, so the condition precedent, public safety is quite here. It is necessary and expedient to do so in the interest of public order and for preventing incitement to the commission of an offence, hereby direct that any telephonic message relating to clandestine contact, movement, activity, etc., to and from, this is the phone number. This is the phone number of the accused Divyajyoti Datta, shall be intercepted and used to the direct to CBI. So this is the order which is required to CBI to intercept the call. Accordingly, we have intercepted. Where is the wrong, Lordship? Similarly, page number 84 is the order for Divyajyoti Datta, and it is same separate order. Phone number is different, Lordship. Page number 86 is again Divyajyoti Datta. Phone number is different, Lordship. Page number 87 is again an order of the competent authority. Phone number is similar to that of page number 86. Divyajyoti, the accused is same, Lordship. 88 is again an order. It is with regard to telephone number of Lal Chand, accused Lal Chand, Lordship. And 89 is again Lal Chand. Phone number is different. Phone number is similar. Period is different, Lordship. From 88 to page number 91 is with regard to the order passed for the telephonic in the conversation of Lal Chand, accused Lal Chand. And 92 is Ankit Jain. Phone number is given, Lordship. So these are the order which empowered CBI to intercept the telephonic conversation which was taken place during that period of time within that stipulated period, Lordship. There is no irregularity done by CBI while intercepting the call. And therefore, after intercepting the call, case has been registered and a trap was laid where the accused persons were apprehended while receiving and demanding bribe money, Lordship. Subsequently, during the investigation of the case, Lordship, we filed this petition seeking permission from the court to take the voice sample. And after purging the case diary, it was rejected. That is the case, Lordship. Whereas, Lordship, in the case diary, the orders are quite available. Copy of all the orders has been supplied to them, Lordship, and Lordship may kindly have a look into the case diary. I fail to understand how the learned trial court, without considering this order, had passed the printing order which was under felon before this honorable court. On the ground that there is no material, Lordship. I flag back, Lordship, that this is the order passed in relation to telephonic conversion, Lordship. So, Lordship will file all the orders prior to filing of the application by the CBI before the trial court, Lordship. All this order has been passed and it was seized by CBI during investigation and it is there in the CD. But the learned trial court failed to consider those orders, Lordship. Only on the, I don't know how he has come to the finding that there is nothing, no material has been placed by CBI, Lordship. The stage was before taking cognizance. Investigation was on in order to ascertain the voice of the conversation with the sample.
When you have filed the petition.
Yes, yes. It was a pre-cognizance stage, Lordship. Cognizance was not taken, investigation was on, and we are willing to take the voice sample in order to ascertain that whether this is the voice sample of this accused person is related to the telephonic conversation which has been intercepted by CBI. So it is a very simple, it's only a mechanical process by which the voice of the accused ought to have been taken by CBI, Lordship. However, Lordship, without considering the orders of the competent authority, this order has been passed, Lordship. Similarly, Lordship, is a case of that other case, Lordship. Fact of the case is similar, I mean this is different, only the similarity is that it is a bribe case, Lordship. Bribe was demanded to the tune of different amount, huge amount has been demanded by the accused person, public servant, in both the cases, and it was accepted, and one of the accused person was apprehended red and white accepting the bribe amount, Lordship. In both the cases, accused were apprehended, Lordship. So therefore, Lordship, I pray before this honorable court to kindly set aside the order passed by the trial court and direct the accused person to give their voice sample as per the provision. Lordship may kindly have a look with regard to the, though there is no provision in the CRPC with regard to giving of the voice sample. However, Lordship, it was settled law in 2019 with Christina, where it has been held, Lordship, that magistrate can order to the accused person to give their voice sample for some reason, Lordship. May I place the judgment of Christina before your Lordship, Lordship? In 2019 HSTC, para 27 and 26, Lordship. May I read, Lordship, para 26 and 27? Today, judicial order compelling a person to give a voice sample violates the fundamental right to 2019 8 SCC, the full bench decision comprising of 3 judges of Honorable Apex Court, Lordship. In para 25, 26 and 27 are the finding, Lordship, where, Lordship, after discussing several laws with regard to right of privacy, this judgment has come into being, Lordship. In para 26, may I read, Lordship? Could a judicial order compelling a person to give a voice, sample of his voice, violates the fundamental right to privacy under Article 23 of the Constitution? Is the next question. The issue is interesting and debatable, but not having been argued before us. It will suffice to note that in view of the opinion rendered by this court in Modern Dental College and Research Center versus State of MP, Govind versus State of MP, and the 9-judge bench in this court in K. Puttaswamy versus Union of India, the fundamental right to privacy cannot be construed as an absolute right, but must bow down to compelling public interest. We refrain from any further discussion and consider it appropriate not to record any further objection and on an issue not specifically raised before us. Para 27. In the light of the above discussion, we unhesitantly take the view that until explicit provisions are engrafted in the Code of Criminal Procedure by the Parliament, a judicial magistrate must be considered the power to order a person to give a voice sample for the purpose of investigation of crime. So this is clear, Lordship. The judicial magistrate is empowered to direct the accused person to give their voice sample. Where is a wrong, Lordship? The only finding of the trial court is that there is no material, whereas the materials are quite available in the CD. That is my respect submission, Lordship. So, Lordship, with regard to this case, Lordship, this is our my submission. Lordship may kindly satisfy the order passed by the London trial court and direct the accused person to appear before the CBI to give a sample. And Lordship, with regard to other case, facts are similar. I mean to say the law points are similar, Lordship. Order is also similar, Lordship. There is no material, whereas materials are there available on the case diary. Lordship can have a look into the record case diary, Lordship. These are the orders which will reflect the fact that the competent authority has passed the order by complying section 419A of the Telegraph Rule. Prior to framing of the 419A, Lordship, the judgment of Puttaswamy, PUCL, guidelines will be framed with regard to the safeguard of the right of privacy of the accused person. That has come to an only after the framing of this rule, Lordship. Now, Lordship, Rule 419A is to be looked into, Lordship. So, we have complied Rule 419A, Lordship. There is no illegality, and therefore, Lordship, the order may be rejected. That's all.
This is a revision. One small issue, my lord, nobody had pointed out. My lord will see the date of the order.
Order is a big.
Order, my lord, Lordship, if you go for the cost title, order is 26/2/2020.
No, page. Order.
21, my lord.
21.
20.
Yes.
They apply for certified copy, 26. My lord will see this revision petition, my lords. The affidavit is filed at 10/6. Affidavit on 10/6. I went to the court records, my lord. It shows, my lord, it was registered on 16th.
Affidavit was
affidavit sworn on 10th. It is registered in the court system on 16th. 16th June, my lord. Now, my lord, the Limitation Act for a moment, my lord. Articles appended to the Limitation Act, my lord. Article 131.
And it's okay. 4 months.
90 days.
No. It's already 4 months.
My lord, yes. Revision is 90 days. I have calculated, my lord, it's 4 months. Approx to 4 months. So, my lord, this application is it's a time barred, my lord. There is no explanation why they was filing any explanation. My lord, will kindly see 131. My lord, got the Limitation Act, my lord?
Yes.
My lord, will see the item number 131. The 131, my lord, it says in to any court for exercise of its power of revision under CPC or CRPC, my lord, it's 90 days. So, my lord, and my lord also will come to, my lord, section 5 of the Limitation Act. Well, there is also 3, my lord, there is a bar of limitation. My lord, there is no single whisper in this application, my lord. Why such delay has occurred, my lord? The judgment I am relying on, my lord. My lord, if a statute says so, a specific process has to be followed, or the statute has a provision that has to be followed. No other provision is, my lord. Another process cannot be resorted to, my lord. Yes, my lord, that famous judgment, my lord, the King Emperor Nazir Ahmed versus King Emperor, my lord. It says, my lord, if a statute provides a manner of doing something, it has to be done in only that manner, my lord. So in this case, my lord, the petition itself is time barred. First, they have to come with a Section 5 application, my lord, Section 9 of the Limitation Act, my lord. My lord, will kindly peruse, my lord, Section 5 of the Limitation Act. First 3 is there is bar, my lord. First 3, my lord. Three is, my lord, there is a bar, and they have ought to resort it to, my lord. Even a single day delay is also fatal, my lord, because this is, my lord, somebody's, my lord's privacy, somebody's life, somebody's fundamental rights, my lord. So no deviation should be permitted, my lord. They should have come with a Section 5 application of the Limitation Act, my lord. They have not done this, my lord. Prima facie, my lord, is time barred. Not to go on merits, my lord. And this, not a single element in the petition lordship I have found that why there was any delay. They cannot blame it on the court also, because the order sheet itself reveals they got the certified copy on 27 also. Well, I rely on a citation, my lord. This is regarding an election petition. Well, this lordship, I pointed out the relevant paragraph. No, my lord, this is also a criminal matter, my lord, where Kofosa was pressed against, my lord. The paragraph 15, my lord, I have just sticked with my pen on the next page. Meaning thereby, my lord, if statute has laid that you should come within 90 days, you must come 90 days. You have a remedy. When you cross those 90 days or limitation, you have to come with a Section 5 application. There is no application, there is no explanation to delay, my lord. Let me satisfy that first. And that after, my lord, I am also relying, my lord. And specific, it's, my lord, since it's a revision, my lord. Appreciation of evidence is not allowed, unless very too much public accession, my lord. So first they have to satisfy that, my lord. Well, again, I am relying on this. This is an election petition, my lord. Para 17 of this petition, it says, my lord, if a well-settled salutary principle that if a statute provides for a thing, well, let's repeat the same. It's in regards to election petition, my lord. So this has to be answered before going in marriage, my lord. My learned senior friend would like to answer that. Other arguments, my lord, they are there. And my lords, these are statutory delays, my lords. Unless an application has come, my lords, delay cannot be condoned by the court itself, my lord. My lord. Other points, my seniors are there, my lord.
My lords.
My lord, just a point, my lords. Even before, my lord, the registration of the petition, revision petition cannot be registered, my lord, without condoning the delay, my lords. Oh, let's.
Let's I am item number 7, respondent number 1. I am submitting a compilation of judgments, my lord, which are material. I will be referring to these judgments. It's the case in brief. The case in brief, the factual matter. The CBI registered an FIR on 11th of April 2018, alleging that there was a criminal conspiracy between various accused persons to extract a bribe of rupees 50 lakhs, which is changed later on to 40 lakhs. And in furtherance of that, certain telephonic conversations is taking place, which they are claiming that they have lawfully intercepted. They are claiming minutes. We are not conceding. So, obviously, to compare it authentically, the voice spectrography is to be conducted, and for that they need the sample voice reciting the same words which are recited in the alleged telephonic intercepted conversation. So, initially on 13th of April 2018, when all of the accused, most of the accused were taken into custody, they approached the learned special judge. Learned special judge, mindful of the pendency of the matter before the Honorable Apex Court, where the Honorable Justice Ananya Prakash Desai, Honorable Justice Aftab Alam have differed among them whether there is any statutory enablement to compel an accused to give the voice sample. Because Article 20, Clause 3 says that you cannot force a person to self-incriminate himself or herself. Justice Ananya Prakash Desai felt that measurement of Prisoners Act of 1920 will probably provide the authority because there is no authority in the CRPC or PC Act or even IPC. Justice Aftab Alam felt that no, the measurement of Prisoner Act is only for the medical condition of the prisoner when he is brought for the first time to the custody or jail. So both of them recommended that matter should be decided by a larger bench. Matter went to the larger bench, Lordship, and a full bench of Honorable Supreme Court, headed by Honorable Justice Ranjan Gogoi, as his Lordship then was, who became Chief Justice of India later on, by their judgment dated 2nd of August 2019, they accepted that there is no statutory provision anywhere, Millets, in any of the statute, in spite of nudging by the Honorable Supreme Court on various occasions in the past. Parliament has not made a provision, so they accepted that the accused person cannot be compelled to give the voice sample. However, in last para 25, Lordship, I have included this judgment. Page 27 may kindly be seen by my lords. That is the last, second judgment, my lords, last page. And para 25 minutes. last page, my lords have got it. In the light of the above discussion, we unhesitatingly take the view that until explicit provisions are engrafted in the code of CRPC by Parliament minutes, unless it is engrafted. So there is an admission by the Honorable Apex Court, there is no such provision. A judicial magistrate must be conceded the power to order a person to give a sample of his voice for the purpose of investigation of a crime. Such power has to be conferred on a magistrate by a process of judicial interpretation and in exercise of jurisdiction vested in the court under Article 142 of the Constitution of India. We accord accordingly. So, minutes. Of course, in my humble opinion, the judgment needs to be revisited by a larger bench because Article 142 is a settled law in a recent judgment also that it's a rule of procedure, it's not a substantive enablement. So only for the substantive justice, procedural handicaps can be taken care of by the Honorable Apex Court. Honorable Apex Court cannot go into the substantive issues under Article 142, but so long as this judgment is there, we are bound, and I am also bound. So I bow down to the directions of their lordships. So lordship, when they went to the first time, on 19th of April 2018, they learned a special judge dismissed the petition of the CBI, saying there is no authority for giving any such direction and matter in any case is pending. They came in a revision before this Honorable Court. No quarrel with that, it is their right. My lord, dates are very crucial. Dates may kindly be taken note of. On the 2nd August 2019, the Honorable Supreme Court laid down this direction, this principle of law, that a judicial magistrate, which will include, of course, a special judge, because that is the first court. So what Supreme Court is saying that the trial court will have to be able to give a direction to the accused to provide voice sample till the time the Parliament takes the call. So that way, millets, on 2nd of August, judgment comes, CBI is well aware of it. Because in earlier judgment order also, this issue has cropped up and it is mentioned in the order dated 19th of April 2018. On 7th of November 2019, millets, 4 months, 3 months rather, sorry. So after 3 months, they withdrew their revision from this Honorable Court, saying that we don't want to pursue. And this order is, millets, is enclosed by them only in their petition. My lords can come to page 45 of the revision petition or criminal petition, whatever they call it. Their petition, my lords. 45 minutes. This is the order of this Honorable Court, millets. Honorable Justice Ruhi Kumari Fukan, date 7/11/2019. In view of the submission of the learned counsel for the petitioner that they are not going to pursue the matter anymore, the present revision petition is stand disposed of on withdrawal. Well, a question arises here. They have made a categorical statement before this Honorable Court, and it is a criminal petition, millets. It was a criminal revision, it is not a civil petition wherein they can invoke the letter patent jurisdiction of the larger bench. They made a categorical statement to my lords before this Honorable Court that they don't want to pursue the matter anymore. It is unqualified, categorical statement. Matter will include the matter of asking for the voice sample. Now, millets, there is no res judicata, concept res judicata in the CRPC, I am aware. But issue estoppel is there because rule of evidence applies to both CRPC and CPC. So issue estoppel will operate. Now, they make another petition to the trial court on the same cause of action, which they have undertaken here not to pursue. And, of course, they fail again. This time on other grounds, which I will just assist my lords when I read the order. So, my lord, the first question which arises here is, can they invoke the revisional jurisdiction again in spite of a specific bar in the law? Because they are invoking section 397. Of course, they are calling it, dishonestly, they are calling it a criminal petition and not a criminal revision petition. But the The moment they invoke section 397, it becomes a criminal revision petition. Why they have done it, I will clarify just few minutes. So, my lord, the first issue, a question of law which arises for my lord's consideration is that whether they can move another application before the first court when they have already failed in their original attempt before this honorable court, which is a superior court, fail again before the trial court, and then come again in section 397, invoking 397, which is basically a second revision by circumventing the provision of law. So that is the first issue of law, my lords. The maintainability of this revision petition, because of their unequivocal, unqualified statement made before this honorable court that they don't want to pursue the matter anymore. Now, these 5 words are very important and crucial, my lords. To pursue, they are not going to pursue the matter anymore. But they have pursued the matter again. In fact, they have committed the contempt of this honorable court. Of course, that is delayed and barred by limitation, etc. But this order is in defiance of their undertaking, their assurance given, solemn assurance given to this one. That's the first thing, Millets. Now, Millets, what my young brother has brilliantly attempted to bring to my lord's attention. What kind of petition is this? Ultimately, Millets, nomenclatures of the petition will not confer jurisdiction. It is the provision of law which confers jurisdiction on the court. Law of jurisdiction is well settled. I need not consume judicial time. I am just citing one judgment, that is the Kumar Saini versus High Court of Delhi. The full bench of Honorable Delhi Supreme Court has very clearly let down it, a recent judgment, let down that jurisdiction cannot be conferred even by agreement between the parties and the court. If my lords do not have jurisdiction, my lords do not have jurisdiction. I cannot create jurisdiction by my act. It has to come from the statute. So jurisdiction, my lords, is a statutory. It cannot be created by any act of the court or an act of the litigants before the court. So, my lords, here is, they have, I am just coming to the first page of the petition, my lords. The index, my lords. I'm sorry, my lords, it's a page 1, it should be not numbered, but index, my lords. In the top, it is written, criminal revisional jurisdiction. So they are invoking, my lords, the revisional jurisdiction of this honorable court. So it has to be 397, read with 401. My lords, as my younger brother has just brought the attention of this court, the criminal revision as per Limitation Act is to be preferred within 90 days. Article 131 is very clear, it's a statutory matter. Section 3 of the Limitation Act is very bluntly, my lords, emphatic, that the court has to dismiss. It casts a command on the court that any petition which is not within the time prescribed has to be dismissed. It's a legislative mandate and command to the court that if a time limit is prescribed and petition is not moved within that time limit, then it has to be dismissed straight away. In fact, as my brother has said, it should not have been entertained by the registry in the first place. So, to overcome this, what they did, they browbeat the registry because they are CBI, struck off the revision in the petition, made it a criminal petition, and circumvented the law, as is their habit, which I will show on the substantive issue just now. So, my lords, my second objection is that this being a criminal revision, which in any case written by them, and in any case, from the body it is clear, if my lords can come just below on the first page, page number 1, in the matter of minutes, just below to the Honorable Chief Justice, an application under section 482 read with section 397, 401. So even if they have a struck off revision, which is
Struck off.
yes, in my it is struck off by pen. This is the copy I have got. My other brothers and sisters are also saying the same thing. This is very deceitful on their part. They could have moved an application, took the liberty of the court, that's a different issue. But a striking off and then not a striking off in the first copy is also a very, very serious, it amounts to tampering of the record.
There put
On the top, my lords.
no, it's not that. I mean, it's there only in the revision.
So in the original they did, but I don't know how they did it in our copies. The copies which they have given, I'm treating it a revision in any case. It's a criminal revision because I'm on the issue of section. I mean, hitting of the section
Do you
3.
have anything to say?
Lordship.
Because our copy is only revision section.
Lordship, actually,
Revision what?
petition has been filed prior to my appointment. Lordship, I have to take the report.
Here it is.
Oh, same. They have given us. In fact, that amount of misleading us, millets. They should not have done it. Millets, it's a very serious issue, millets. It amounts to tempering and misrepresentation to the litigant. Because in court's copy, they have not struck off. In our copy, they have struck off. इंडेक्स का हमारे मेमोरी ठीक है तो सेक्शन वो किया पेमेंट In fact, Millets, what my learned sister is saying, it has been struck off in everybody's copy. Yes. I mean, not in every copy and every page, yes. Yes, this has been done. So, Millet, though it is a very serious impropriety and violation of judicial discipline,
whatever, we are treating it as
a revision, criminal revision, Millets. Because
it is filed under
397 and 401 is being invoked, so it is a revision petition. Millets. I am also treating a revision petition. Millets. So, Millets, once it is a revision petition, it will be covered by Section 3 of the Limitation Act and Article 131 of the Limitation Act. That means 90 days from the date they got the certified copy. So, assuming they have taken the copy sometimes in the month of March 2018, so 90 days will be over sometimes in the first week of July. They have come much later, next week. So, Millets, it is hit by limitation. Exact date I will give my synopsis, Millets, after calculating. So, Millets, it is first hit by Section 3. Section 3 cannot be lifted. Now, Millets, the legislature is conscious of the bona fide delays. Legislature is conscious that litigants from both sides, the state as well as the private litigants, there may be bona fide cases where they may not be able to approach the Honorable Court within the prescribed 90 days. So, legislature has provided an omnibus general remedy in the form of Section 5. Now, law is very clear on the scope of Section 5 that there has to be a prayer by way of a separate petition under Section 5 of the Limitation Act for condonation of delay. And that prayer will have to be adjudicated first. Only then the merits of the main substantive prayer will be considered by the court. In this case, Lordship, with due respect, there is no prayer for condonation of delay. That is the lifting of the bar of Section 3. So in that case, Millets, this petition is barred by limitation, has to be dismissed mandatorily because they are not asking my lords to invoke, because we have a right to assist my lords even on the applicability of Section 5 of the Limitation Act. We may be able to satisfy that the indulgence of the court may not be available to them because of the various factors. So by depriving us our inherent right, a valuable right to assist my lords over the ambit and scope of Section 5 of the Limitation Act, they are again acting deceitfully. So my respectful submission, Millets, that on this ground itself this petition is liable to be dismissed. Of course, this court has jurisdiction to ask them, to give them leave as an officer of the court, Millets. My lords can allow them to move an application afresh, allow us to assist my lords on that, and then my lords can take a view either way and then proceed if required. So that is there. It is not that it is barred forever. Probably they will have to explain the delay in moving the condonation of delay application also. So leaving that to my lord's jurisdiction, my lord, now I am coming to main issue, my lords. Now, my lords, the Indian Indian Telegraph Act 1885 has a provision, section 5, subsection 2, which prohibits interception of telegraph, but by way of exception permits it under certain circumstances. There are various conditions, but two conditions are material, that is public emergency and public safety. It is for this honorable court to consider what is the ambit of public emergency and public safety. There is no public emergency, millets, because there is no fire, there is no earthquake, there is no rioting, nothing. So public safety is something, there is not a single word in their application that their case is covered by the public safety. So millets, leaving it that, I will come to it again later. The Indian Telegraph Rules 1955 did not have any provision regarding the interception, the permissible interception of the telegraphic communication. So in the case of People's Union of Civil Liberties, the Honorable Apex Court examined this issue and gave specific directions to the Union of India to formulate rules so that the conduct is not arbitrary, it is regulated by the rule of law. In respectful compliance of the same, millet, the rules were framed, which are called Rule 419 capital A of the Indian Telegraph Rules. My lords can come to page 35 or my booklet, millet. I have enclosed it. So, millets, this is GSR 193E, dated 1st of March 2007. So, millets, an elaborate scheme has been prescribed. My learned brother, appearing for CBI, has been repeatedly saying that we have intercepted as per law, while the learned special judge has very correctly and emphatically said that you have not intercepted as per law. So, millets, with due respect, the learned special judge is right and the CBI is wrong. They are misrepresenting factually and legally. From this GSR itself, I will show that how learned judge is correct and how the CBI is in wrong. Millets, I can be permitted to read clause 2 of this GSR, millets. In the Indian Telegraph Rules 1951, after Rule 419, the following rules shall be substituted, namely 419A, Subrule 1. Directions for interception of any message or class of messages under subsection 2 of section 5 of the Indian Telegraph Act 1885, hereinafter referred to as the said Act, shall not be issued, Miller. So there is a bar. Bar is the normal, exception is the permission. Except by an order made by the Secretary to the Government of India and the Ministry of Home Affairs. So meaning thereby, millets, for a central agency, no permission shall be granted to intercept the telegraphic communication except by a written order of the Secretary of the Home Affairs, Ministry of Home Affairs, Government of India. Exceptions are there, millets, in this para only. Next, fourth line. In avoidable circumstances, such order may be made by an officer not below the rank of Joint Secretary to the Government of India who has been duly authorized. So now, millets, legislature has taken care that Secretary Home Affairs is a very busy person. He might be busy in too many other things. There may be emergent situation where permission may be required within hours. So in that case, Secretary has been given the option to authorize an officer to deputize him not below the rank of Joint Secretary to the Government of India to do it on his behalf. And there, of course, has to be regularized within 3 days. Now, millet, there is one more exception. The millet can come just below after the provision. It says, provided that in emergent cases in remote areas where obtaining of prior directions for interception of message or class of message is not feasible, for operational regions where obtaining of prior directions for interception of message is not feasible. So two conditions, again exceptions, further exceptions that we made. It says the required interception of any message that class members shall be carried out with the prior approval of the head or the second senior most officer. So meaning thereby, Millets, the legislature has very consciously provided that there may be a situation, a scenario where even approaching the joint secretary in the Ministry of Home Affairs may not be feasible word. That means operational region, practical region, location, etc., etc. So in that case, head of the department or second senior most, that is the number 2, can give this permission. Now, Millets, this is with riders. It says, at the so and so in the case of a state government, then says the concerned competent authority shall be informed of such interception by the approving authority within 3 working days, and that such interception shall be got confirmed by the concerned competent authority within a period of 7 working days. So, Millets, in the case, it is the head of organization, in this case, director CBI or the special director CBI, the number 1 and number 2 in the CBI, if they have been approached and given the permission because of some operational reason, they have to inform the Home Secretary within 3 days, and they have to get it confirmed by the Home Secretary within 7 days. My lords, admittedly, from their application only, they have taken 13 approvals, my lords. My lords, if my lords can come to page 6 of their application, para 10. Millets, para 10 millets on page 6 of their revision petition millets. That out of 13 numbers of letter of permission for interception, 8 permissions granted by the Union Home Secretary to the Government of India, and 5 permission issued by the worthy director of CBI after duly examining the request and considering the facts so and so. So let's, these 5, and I am one of them. The accused number is one of those 5. In my case, permission is granted by the director and not by the Home Secretary. I will show it from the chart sheet. So, millets, out of 13 numbers for which permissions have been granted, that is 13 permissions, 8 are according to them only, because we don't have access to the primary records. 8 are by the Home Secretary of the central government and 5 are the director CBI. In these 5 cases, millets, within 3 days of the permission granted by the director CBI, the Home Secretary was to be informed, and within 7 days from the date of permission granted by the director CBI, the approval of the Home Secretary was to be obtained or interception was to be closed. The collected material was to be destroyed. Millets, I am daring with due respect, Miller, and humility, if they can show that they have informed the Home Secretary. So these 5 go. These 5 are patently illegal. On merits, millets. Even if we ignore for the time being, because that is a remedy which can be condoned. But on merits, out of 13, 5 are unlawful because they have not complied with the requirement of law to inform the Home Secretary of the Government of India within 3 days and to obtain the approval of the Government of India within 7 days. So those 5 are illegal, ex specie, ab initio, res ipsa loquitur, and cannot be acted upon. That is why the learned special judge has returned a finding that you have not complied with the law. Now, millets, I will request my lords to come to GSR 193 once again. Millets. Millets, sub-rule 2 of Rule 419A, that is on the outer side, that the right hand column, millets, top, sub-rule 2, millets, page 35. Sub-rule 2, any order issued by the competent authority, which is the Secretary, Home Affairs, under Sub-rule 1, shall contain reasons for such directions, and a copy of such order shall be forwarded to the concerned review committee within a period of 7 working days. My lord, the permission does not end the requirement of law. There are 3 stages. One is, you have to have the permission. Second is, it has to be sent to the review committee. There is a review committee, my lords, which is, my lords can come to sub-rule 16 on the next page, my lords, page 36. Page 36, next page. Sub-rule 16 at the bottom. The central government and the state government, as the case may be, shall constitute a review committee. The review committee to be constituted by the central government shall consist of the following, namely, millets: Cabinet Secretary, Secretary to the Government of India, Department in charge Legal Affairs, Secretary to the Government of India, Department Telecommunications. So, millets, the decision or the order of the Secretary to the Ministry of Home Affairs is subject to the mandatory statutory approval of a high-powered review committee comprising of the senior-most bureaucrat in the Government of India and 2 another senior-most bureaucrats comprising of the 3 secretaries, the Secretary of the full Cabinet, which is called Cabinet Secretary, the Secretary of the Department of Legal Affairs, that is called Law Secretary, and the Secretary of the Department of Telecommunications, that is the Telecom Secretary. So these secretaries have to get a copy of the order given by the Secretary of Home Affairs within 7 days. If they approve, which is the next provision, if they approve, interception will continue. If they do not approve, in Rule 17 is very clear, millets, Rule 17 and this column only, the review committee shall meet at least once in 2 months and record its findings whether the directions issued under Sub-Rule 1, that is the Secretary of Home Affairs, are in accordance with the provisions of subsection 2 of section 5 of the said Act. When the review committee is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions and order for destruction of the copies of the intercepted message or class of messages. My lord, this is very clear that if the review committee overrules the Secretary Ministry of Home Affairs, not only interception will stop, but the entire material which has been collected by way of interception will have to be destroyed mandatorily, statutorily. I will withdraw, my lords, I will concede this revision if my learned brother can show to this honorable court one single out of 13 approval by the review committee or reference to the review committee. My information, as collected from their officers only, is very clear that they do not have a practice of informing the review committee. They just don't inform. And they have not informed the review committee. On this ground alone, my lords, nothing else, on this ground alone, the order of the learned special judge is correct and legally appropriate because they have not complied with the provisions of Sub-Rule 16 of Rule 419A. They have just not intimated the review committee, which is an overriding committee. It is just like, my lords, a session court condemning an accused with the capital punishment and not referring the matter to the Honorable High Court for confirmation of the death sentence. They have to destroy mandatorily. Though they are not aware, there is a judgment by Honorable Bombay High Court, Vinay Kumar, that has been stayed by the Supreme Court for destruction part. But there is another judgment by Honorable Delhi High Court, same directions, destroy the intercepted material. That judgment is operating. CBI is the same. So even if the judgment of the Honorable Bombay High Court is under stay by the Honorable Supreme Court, the Delhi High Court is operating and they are duty bound. So millets, on this ground alone, the entire interception is illegal. It is deemed destroyed within 2 months of the date of permission given by the Home Secretary. Because first meeting has taken place within 2 months. So even if meeting takes on 60th day, I am taking the longest possible duration. So millets, now I will invite my lords to the charge sheet. what the charge sheet says. Charge sheet. Give me charge sheet. Charge sheet. This is my copy. No? One copy to the board. Charge sheet. Madam. So, my lords, this is the charge sheet submitted by them. My lords can come to page 18 or 19, inner page 18, running page 19, my lords. 19, my lords, para 31. They have given a tabular chart regarding all the numbers which they have intercepted. My lords, in the fourth column from the top, I am Shwetab Suman. The permission given by the Home Secretary for this number is 9th of April 2018. Then for another number, the permission given by the Director CBI is 9th of April 2018. And then another permission is given on 13th of April 2018. So, let's counting 60 days from these dates, the records have to be mandatorily destroyed, and I assume that has been destroyed. Something which is ordered by the law to be destroyed, even if it is not destroyed, it will be treated as destroyed. It will not exist in the eyes of the law. Learned special judge did them a favor that he did not write all these things in the order, because that would have conferred immediately valuable rights on the accused to go for quashing of the entire case. In fact, learned special judge has saved them. They should not criticize the learned special judge that he has passed an incorrect or wrong order. At that ground, had it been shown that they are acting unlawfully, the entire case would have been hit by the illegality, and Honorable High Court would have been approached by us under Section 482 CRPC for quashing of the entire criminal proceeding. So, Millets, non-compliance of Section 216, Rule 216, invokes the provisions of Rule 217 of the Rule 4919A, and everything is illegal. Millets. Now coming to this chart again, Millets. They have taken the permission of the Home Secretary on 9/4/2018. That means, Millets, Home Secretary is available. Kwame Millett, that is accused number 1. Home Secretary is available. They can approach him. So why did they take the permission of the director in another number? This is backdating, Millets. Since it is internal, they have just fabricated by backdating their records. For one number, my number, they have gone to the Home Secretary. Home Secretary has obliged, meaning thereby Home Secretary is conscious of their request, has considered their request. For other number, they say we are in remote area. What kind of argument is this? Because nothing came out in this number in which they took the permission. They wanted to implicate me through another number. By that time, I was already taken into custody. I will show something very funny. My Lord's judicial conscience will be shocked what they have done in my case. So, they cooked up their internal documents saying that we are in remote area, we cannot approach the Home Secretary. So our director is giving us permission. When on the same date, they have approached the Home Secretary, Kwame only took the permission. Now, Millets, I am showing something, Millets, in this charge sheet itself. Arrest memo. Arrest memo. Millets, in the charge sheet, my lords can come to page number 3, Millets. The kind of investigation CBI is doing, the rights and life and liberty of the citizens are being spoiled and destroyed by them. No, this is very. Millets, A1 I am the accused, column 11 of this table. My lords can see the sub column 10 running 1 to 10 minutes. Date of arrest 13/4/2018 minutes. This is the charge sheet, millets. On this I am being prosecuted. Now, millets, I will request my lords to kindly see the arrest memo. Don't arrest memo. Arrest memo. My lords can come to column 11. Arrest cum personal search memo. Date and time of arrest 12/4/2018 at 20:15 hours. When did they arrest me? And why this tempering? My lords, then place of arrest. CBI office, AC1, New Delhi. How did I land in CBI office, my lords? In the evening. I am in Delhi, at Noida, in my house. Something happens in Guwahati. I am arrested in Delhi, no issue. Law provides for that. But how did I reach the CBI office where they arrested me? No summons under section 41A was issued to me. They have not shown it, they have not filed in the court. Well, the Honorable Bombay High Court has set aside and quashed the arrest by the CBI only in the case of Chanda Kochar and Deepak Kochar, and that has been upheld by the Honorable Supreme Court because the maximum possible punishment under PC Act is 7 years. That means Arnesh Kumar versus State of Bihar is applicable. Since CBI does not know perhaps the Arnesh Kumar in State of Bihar and the requirements of arresting a person, the Bombay High Court quashed the entire arrest and Honorable Supreme Court refused to intervene and dismiss their SLP, so law has become final limits. So my arrest is illegal. Once my arrest itself is illegal, do they have any case to ask for my voice sample? That is not the only end of this. I will show many more such things. Millets, in the case of Pankaj Bansal versus Enforcement Directorate, the Honorable Apex Court said that if section 19, subsection 1 of the PMLA 2002 is not complied with, Pankaj Bansal versus Enforcement Directorate, Millet, recent judgment, if section 19(1) is PMLA is not complied with, the arrest is illegal. 19(1) is a specific provision pari materia to 41A of CRPC. But they added henceforth. Millets, in the case of recent judgment, just now, 16th of May, in the case of Prabir Purkayast versus State of NCT of Delhi, the another bench of Honorable Supreme Court has extended it to others also, including UAPA, and their lordships have quashed the arrest of Mr. Prabir Purkayast as illegal because he was not given the grounds of arrest. They did not give me anything. They arrested me in Delhi, Millets, in CBI office. Let them inform this Honorable Court on affidavit how from Noida to CBI office, which is the CGO complex, Delhi, a distance of about 25 kilometers, I reached there where they could arrest me. They abducted me. I'm using the word abducted in the legal sense, Millets, with due respect. They abducted me from my residence in Noida, which is sector 50, 10 kilometers inside the Noida, then another 15 kilometers inside Delhi, brought me to CBI office forcibly, and there they arrested me, draw a arrest memo. My lord, that is not the end of the illegality. The CBI deserves absolutely no indulgence of any honorable court anywhere in the country because of their such conduct. How did I, arrested within the jurisdiction of learned district judge and district and session judge New Delhi, within whose territorial jurisdiction the CBI office lies, and arrested within the territorial jurisdiction of Honorable Delhi High Court, landed in Guwahati, Millets. Where is the transit remand? Who permitted them? Who permitted them to smuggle me, transport me like a bonded labor, like a black slave, from Delhi to Guwahati, a distance of 2,000 kilometers? Well, its law is very clear. CRPC is very clear. Each state is a separate session unit. So the state of Delhi is a separate session unit, Millets. And it has a high court. Now nobody can be taken away from the jurisdiction of the session unit Delhi to another session unit without the permission of the local court. Police is aware. They take transit remand, that's why. I was entitled for bail at the stage of transit remand also, Millets. I could have been released by the court theoretically. They just lifted me, took me CBI office, arrested me, put me in the flight next morning, brought me here. Law be damned. Then, there is another funny situation, Millets, in this charge sheet only.
Lordship, may I interrupt? Lordship, are we here for quashing of the FIR or quashing of the charge? It is not the case, Lordship. Here we have a different thing, Lordship. Let them argue on that point, Lordship. We are not in a bail petition, Lordship. So making such argument is wasting of time, Lordship.
Lords, I am showing the conduct. Can they be trusted? Such kind of Millets, ultimately it's the life and liberty of a person. My liberty cannot be taken away otherwise than due process of law. Here is an agency which has no respect for law. That is what I am saying. They are abusing the learned special judge, saying he has the learned special judge passed a wrong order or incorrect order.
Compliance of subsection 16 or 17 of 419.
But that itself is sufficient, Millets. But see their conduct. Millets. Then in this charge sheet alone, I'm not pressing further, but in this charge sheet itself, they have said that I was arrested from my residence. So, 3 dates, 3 places. What I am saying is that here is an agency which neither knows the law, nor cares to find out what is the law, nor respects the law, nor respects the courts. What I am saying is, I agree, I bow down, I am a responsible person, and me as an advocate, as an officer of the court, will certainly not come in the way of the law. Whatever be the instructions of my client, my duty to the court comes first. So, Lordship, with due respect, if the law requires something, it must be done. Because ultimately, I am also invoking the law only before my lords. So, law has to be respected, complied with. But whether a litigant who is seeking indulgence of the court deserves the indulgence when his conduct is like this, that is the issue. The crux is that your conduct does not inspire any indulgence from this honorable court or any other court because you are indulging in such kind of manufacturing. You are not a manufacturer. You are an investigator. So, Millets, what I am saying is, that is one. Even if we ignore it, they are not even aware, Millets. There is another law. Telegraph Act is not the only law, Millets. There is one more law which they have to comply. That is Indian Information Technology Act 2000. Section 69 of the Information Technology puts much larger and much stricter restrictions on any interception. It uses 3 words. Telegraph Act uses only interception. The Section 69 of Information Technology Act uses 3 words. 69, Section 9 of Information Technology Act 2000. It says no interception, decryption and monitoring. Now it is much larger because Telegraph Act is much older, more than 140 years. Information Technology Act is only 25 years. So it has taken into concern everything. Decryption, monitoring and interception. All 3 are banned unless lifted. The rules have been framed. I have annexed it, Millets. Millets can come to page 38 of my booklet, Millets. This is GSR 780E, dated 27th October 2009. Millets, everything has been defined, so I am not taking much time. But 419 has been incorporated in this also. And now decryption has been defined, monitoring has been defined, interception has been defined, which is not defined in the telegraph rules. So this is more comprehensive, more substantive. Let them show one permission taken under these rules. These rules are also operating. They are not aware. anywhere in the country, they don't know that these rules are also there, these laws are also there. So, millets, even if they succeed under telegraph rules, these rules which are much larger, decryption will include any further testing of the voice. Once the voice is recorded, it will be digitally recorded, millets. So it is a digital process. So nothing can be done of anything which has not been done in accordance with these rules. So even if the bar under Rule 419A telegraph rules is lifted, assuming for the sake of argument, I am not conceding, but for the sake of argument, even if it is lifted, the bar remains in place, which is much larger bar, much stricter, and much up to date. It defines everything. The three words in between them, monitoring, decryption, and interception, defines entire digital process of hearing, recording, comparing, everything. So, millets, there is not a word in the charge sheet that they have taken the permission, same Home Secretary, same review committee, everything is the same. So where they have sent one letter, they could have sent two letters, or they could have said that please grant permission under telegraph rules also, as well as the information technology rule also. So no extra paperwork, just mentioning one more law, one more rules. So therefore, millets, now I will draw my Lord's attention to the order, impugned order, millets. This is on page 46 onwards, millets, of their application, millets. Millets, material part I will read, I will skip the introductory part. Page 49, millets, para 11 onwards. From the aforesaid discussion, it is clear that if the voice sample sought by the investigating authority is with regard to intercepted or tapped telephonic communication, then the voice sample can be given only if such intercepted conversations have been duly intercepted as per the prescribed procedure and the principle of law laid down by the Honorable Supreme Court. So, millets, the finding is very clear that voice sample can be directed to be given if your act is as per law. The Honorable Special Judge has restrained himself from going into the details because that would have exposed them further. A great favor has been done. And I may say it is the foot is on the other, shoe is on the other foot. It is a prejudice to us that certain details of their illegal conduct has not been disclosed in the order of the court. Now it says, millets, as discussed and narrated above, it also has to meet the criteria of public emergency or interest of public safety in terms of Section 5(2) of the Telegraph Act and the principles laid down with regard to the same in the case of PUCL. So that also same thing, the compliance of the applicable law. Now para 12, millets, learned PP CBI has placed before me the case diary and I have perused the relevant portions thereof. As mentioned earlier, with regard to the telephone tapping, I have noticed a letter dated 12/4/2018 written by the SP CBI so-and-so to so-and-so, wherein it is indicated that in para 4 that the original copies of the permission granted by the Union Home Secretary for phone numbers, there are 7 numbers, may be collected from the so-and-so, so-and-so. Permission has been granted, millets. There is no reference to approval given by the review committee. That is 216 and 217. Now para 13, millets. However, in my considered view, the materials that I have perused in the case diary do not indicate as to whether the complete due and proper procedure has been followed with regard to telephone tapping in this case in terms of the provisions of Section 2 of the Section 5 of Telegraph Act, Rule 419 of the Telegraph Rules, and the principle laid down by the Supreme Court. So, millets, learned special judge has returned a clear finding that you have not complied with the law and therefore you are not entitled. So, then let's para 14. Fourth line from the top. Required by law has been followed, that has not been followed. The criteria and principle of public emergency and interest of public safety required for telephone tapping as laid down in PUCL case also does not apply in the instant case. So, Millard, there is a finding of fact. It's not a question of law now. The learned special judge has returned a finding of fact that public safety and public emergency are not available. Where they have said in their petition that these are the regions because of which the criteria of public safety and public emergency are applicable, and which has been incorrectly or wrongly rejected by the learned special judge. There is not a single word. Just by saying that order is wrong, order does not become wrong. It has to be shown to be wrong. So what can be the possible ingredients of public safety and public emergency? That should have been disclosed. Where those were present or not according to them, that should have been stated. And then how the learned special judge failed to consider those ingredients, that should have been stated. Then only probably my lord's jurisdiction could have been invoked to consider. So what they are doing is, they are depriving me from assisting this honorable court regarding non-applicability because of non-availability of the ingredients of public safety and public emergency by remaining silent, again deceitful conduct. How do I elaborate, how do I defend the order of the court below unless I am told what particular ingredient of public safety and public emergency was present in this case? There is not a single word. I do not know what to say because I do not know what has been held against me. And now they are coming and saying the learned special judge has passed a wrong order, it should be set aside, and they should be allowed to continue with their illegal activities against me. So, para 15 minutes. Consequently, the petition filed by the CBI is unable to pass the test of the telephone conversations having been tapped in keeping with the provisions of section 5.2. Now, this is conclusion minutes. The learned special judge has examined their case diary, to which I am not privy, I don't have access, found nothing. That means in the case diary, nothing is recorded. Qua the availability of public safety and public emergency ingredients, and therefore learned judge was not satisfied. So he returned the finding in para 15. Then minutes para 16. In such a situation, since the case of the investigating authority for voice sample is failing due to invalid telephonic interception, therefore this court need not go more. So let's summarizing, the learned special judge has gone deeper, looked into all the material which is not available, which is not permitted by law to be accessed by the accused, has found nothing. So least that was required by them. They should have stated in their petition that these are the ingredients of public safety and public emergency which were operating at the material time, which compelled us to take recourse to the exception carved out in the law, and that is why the permission was granted by the Secretary Home Affairs. That is why the order of the Secretary Home Affairs was approved by the review committee of the cabinet, led by the cabinet secretary, and that's why we have done it. We could have assisted the court. Since they have not said anything about the public safety and public emergency, learned special judge cannot create it for them. Learned special judge already favored them by not writing all the details. So, because of that, Millard, summarizing it, first of all, it is a second revision. You cannot circumvent the bar under section 397, subsection 3, by filing another application before the trial court when you have taken no leave and liberty. Millard, though it is on the civil side, but the principle of law is applicable, Millard. Last judgment, that is the third judgment of my paper book, Millard. This is page 28 to 34 minutes. It's a quite old judgment, Millard. Most of us know it. My lords may be knowing it. Sarguja Transport Services versus State Transport Appellate Tribunal, Madhya Pradesh. 1987 judgment, Millard, but it's holding law, holding the fort. It says that when a writ is withdrawn without the liberty to re-agitate the issue cannot be re-agitated. And Millets, it is rule of procedure. It is not some statutory provision or something. It is judicial discipline. So even if res judicata does not apply to criminal cases, the judicial discipline will apply. So when they have withdrawn their criminal revision before this honorable court, they were well within their rights to pray for the leave and liberty of this honorable court to re-agitate the issue in the light of the new development, which this honorable court could have easily allowed. They didn't seek anything, so they are hit by Sarguja Transport. That is the first thing. Second, they are hit by Section 3 of the Limitation Act. Then they are hit by the non-compliance of the due process of law. And they are also hit by their deceitful conduct all along, starting from that striking of that revision word and coming to all this, arresting me in 3 places on 3 dates at 3 different times, abducting me from Delhi, bringing me illegally, smuggling me rather to Guwahati and all those things. So even if they are not legally, very strictly speaking, material, but they are material to show their kind of conduct they are having or the arrogance which they have, the lack of respect for the law. So in totality, considering everything, the order of the learned special judge requires no intervention by this honorable court, deserves to be confirmed with heavy strictures against them, Millets. That's my respectful submission.
What to put your on
Item number 6, Your Lordship.
item 6, 145.
145, Your Lordship. So far as Your Lordship, my petition is concerned, it is a criminal revision petition. There is nothing is there, Your Lordship. And that ground, Your Lordship, has already been elaborately argued, Your Lordship, on the point of Your Lordship limitation, Your Lordship. So I will not go into that, Your Lordship. So far as the present petitioner is concerned, Your Lordship, Your Lordship may
How
kindly...
many petitions how many respondents are there?
Here, Your Lordship, I am appearing for respondent number 1.
1.
And there are other 2, 3, 4, 5. Total 5 respondents are there. And probably, Your Lordship, 4 has already been discharged. Not discharged, Your Lordship, no charge sheet has been filed against 3 and 4. They were not named in the charge sheet file. Charge sheet named, Your Lordship, 1, 2 and 5. Now issue basically, Your Lordship, is same, Your Lordship. In my case also, Your Lordship, it's on the ground that there is a violation of the rule 419A of the Indian Telegraph Rules. Therefore, the Honorable Learned Court below, Your Lordship, decided, Your Lordship, the petition filed by them, Your Lordship, against them, Your Lordship, CBI, Your Lordship. Now, Your Lordship, may kindly come to page 21 of the petition, Your Lordship, the order. The page 21 of the criminal petition number 145. Para 3, Your Lordship. They have relied on Ritesh Sinha, Your Lordship. The learned prosecution has placed before me the judgment of the Honorable Supreme Court rendered in case of Ritesh Sinha versus State of UP 2019-861. Drawing my attention to para 27, where it has been held that the judicial magistrate has the power to direct the accused to give his voice sample for the purpose of crime investigation He further submits that as stated in the petition filed by CBI, such voice samples are needed in case of investigation of the alleged offence of bribery and exchange of illegal money. Then, Your Lordship, there was a reference to, Your Lordship may kindly come to para 6, Your Lordship. Now, as regards the first question, the decision of the Honorable Supreme Court in the case of Ritesh Sinha makes it quite clear that until explicit provisions are made in CRPC, the Honorable Supreme Court, in exercise of its plenary power under Article 142 of the Constitution of India, has held the judicial magistrate would have to be the power to order a person to give his voice samples for crime investigation. Therefore, the existence of such power in this court is no longer in doubt. This is important. There cannot be a quarrel on that point, Your Lordship, that as after passing of the judgment in Ritesh Sinha, the magistrate has the power to direct the accused to give his voice sample. Now the question that remains, Your Lordship, whether under what circumstances that order can be passed. Therefore, Your Lordship, what my learned friend has submitted regarding Ritesh Sinha, that the power, so far as the power is concerned, there is no quarrel about that, Your Lordship, and we are not disputing that. But only thing, the circumstances under which the magistrate can pass that order, Your Lordship, that is the question in the present batch of petitions, Your Lordship. And for that, Your Lordship, to look at the circumstances, Your Lordship, we will have to, Your Lordship, go back to 419, Your Lordship, read with Your Lordship, Section 5 of the Indian Telegraph Act. Your Lordship. Now, Your Lordship will kindly, therefore, Your Lordship will kindly see in the later paragraph of this order, Your Lordship, the learned court below has dealt with the issue, Your Lordship. So, para 7. The second question formulated by this court as above is the most important one in this case, as the learned defense counsel has put the thrust of his argument on the same. Admittedly, in the instant case, the voice conversations recorded are by way of intercepted telephonic voice conversations. Right. In this regard, apart from the decision in PUCL Supra, I have also perused the decision of the Honorable Bombay High Court rendered in the case of Vinit Kumar versus CBI 2019 SCC Online Mumbai so-and-so. Section 5.2 of the Indian Telegraph Act 1885 deals with the power of the government to intercept telegraphic messages, and it provides that such interception could be done only on the occurrence of public emergency or in the interest of public safety. In the PUCL case, it has been clarified that occurrence of public emergency or in the interest of public safety are essential conditions for applying the provision of Section 5.2 of the Telegraph Act, and that in the absence thereof, the authority have no jurisdiction to resort to telephone top tapping. Now, Your Lordship will have to see that whether in the order passed by the Home Secretary, Your Lordship, these issues reflects or not. Whether the order reflects that these situations is there, and if it reflects whether the objective basis of that finding is there or not, Your Lord. By simply saying that there are public emergency or in the interest of public safety, that will not do, Your Lordship. It must reflect the objective basis of that satisfaction by the concerned officer, Your Lordship. And we will have to therefore see in that particular order it is reflected or not. Now, it has been further explained that there are two conditions are not secretive conditions, and occurrence of any of them would be apparent to a reasonable person. After PUCL judgment, several rules have also been framed to regulate such interceptions. I have perused Rule 419 in this regard. In the case of Vinit Kumar Supra, Honorable Bombay High Court found that the interceptions were not in accordance with the aforesaid laws and principles and were held to be invalid, and the court directed destruction of these recordings and barred the trial court from considering the same in its proceeding, out of which the case has gone to the High Court. In the case of Vinit Kumar, it was also held by the Honorable High Court of Mumbai in paragraph 39 that to declare the divorce the fundamental rights in the administration of criminal law, the aim should justify the name should amount to declaring that the government authorities may violate any direction of the Supreme Court or mandatory statutory rules to secure evidence against the citizens. On the basis of the aforesaid discussion, I am of the considered view that if the voice sample sought by the investigating authorities with regard to intercepted or tapped telephonic communication, any voice sample can be given only if such intercepted conversations have been duly intercepted as per the prescribed procedure and the principles of law laid down by the Supreme Court as discussed and narrated above. Coming to the facts of the case, I have perused the petition of CBI, the relevant areas of the case records, and also relevant portions of the case diary produced before me. The CBI has not been able to place any material before the court to satisfy it that the intercepted telephonic conversation with regard to which the voice sample is needed have been duly intercepted in accordance with the aforesaid procedure and the settled principle of law pertaining to telephone tapping. Further, the circumstances in which the conversations have been intercepted also do not, in my considered view, fall within the ambit of criteria of public emergency or the interest of public safety as laid down the PSL case in the context of Section 5(2) of Telegraph Act 1885. Now, these are the basis. Your Honor will kindly see, Your Lordship will kindly see that the 419 Your Lordship has already gone through for the sake of my argument. It is there in the page 26. Your Lordship will find that apart from in this petition also it is there, Your Lordship. Your Lordship will find that apart from the fact that this will have to be passed by the Home Secretary or any officer, Your Lordship, to whom the power is delegated, Your Lordship, there are other provisions, Your Lordship, which are mandatory in nature, Your Lordship. And these provisions include, Your Lordship, the sending of the order to the review committee. And that's why, Your Honor, the Rule 419A, Your Lordship, Sub-Rule 17, the review committee shall meet at least once in 2 months and record its finding whether the direction issued by Sub-Rule 1 are in accordance with the provision of Subsection 2 of the Section 5 of the Act. This is the mandatory requirement of the law. And that too, why it is mandatory, Your Lordship will kindly see, this has something to do with the Article 21, right to privacy as enshrined in our Constitution, Your Lordship. After coming of the Puttaswamy's judgment, Your Lordship will find that right to privacy has been declared as a fundamental right, Your Lordship. Prior to that, there are disputes about that. Kharak Singh's judgment is there, which has been virtually overruled by in the Puttaswamy's judgment. And therefore, Your Lordship, when it comes to the question of infringement of fundamental right of a citizen, then the question of, Your Lordship, this procedural safeguard, Your Lordship, gains importance, Your Lordship. It will have to be mandatorily followed. We cannot look at these rules only in the perspective of a particular case, Your Lordship. We will have to look at it from the larger perspective of the fundamental right, Your Lordship, how it can be affected or how it can affect the citizens as such, Your Lordship. That's the point, Your Lordship, and therefore my humble submission is this, Your Lordship, that these procedures, Your Lordship, the mandatory in nature, and that will have to be followed, and the finding of the learned court below, Your Lordship, to that regard is not only about the absence of the order. It says, Your Lordship, that procedure has not been followed, which is mandatory in nature. And procedure includes the sending of the files to the review committee looking at it, and Your Lordship will find they are completely silent on this. Your Lordship will kindly take up my affidavit in opposition, Your Lordship, in this particular case, in which I have specifically raised this point, Your Lordship, in para 9, Your Lordship, of my affidavit in opposition. Lordship. In the instant matter, authority resorted to illegal interception of telephonic conversations without any occurrence of any public emergency or in the interest of public safety, thereby invading the right to privacy. Besides that, there is no mention of compliance of the sub-rule 16 and 17 of Rule 419A of the Indian Telegraph Amendment Rules 2007 regarding the constitution of review committee and its role in the monitoring of such telephone tapping, which is more relevant considering the period of interception of the telephonic conversations done as early from November 2018 and continued for more than the time limit of 60 days. Now, Your Lordship, their reply, Your Lordship, will find to this, Your Lordship, that is in para page 40, Your Lordship, of their rejoinder affidavit, Your Lordship. That the affirmance made in para 9 is denied being devoid of merits. General denial, Your Lordship. It is submitted the right of privacy is not an absolute right and reasonable restriction can be imposed by the state. That has no quarrel with this, Your Lordship. Accused respondent number 1 is habitually involved in the commission of grave offences like corruption which endanger public safety. As such crimes ultimately affect the economic stability and safety of the country and citizens. The interception of telephonic calls of the accused respondent number was necessary for unearthing the larger cause. Therefore, permission of interceptions of telephones were accorded by the competent authority as per the procedure laid down under Section 5.2 of the Telegraph Act 1895, Rule 419A of the Telegraph Rules 1951, after being satisfied that the matter relates to public safety. That it is further submitted that only when the review committee is of the opinion that the directions are not in accordance with provision above, it may set aside for direction of order for destruction of copies of the intercepted message or class of. In this case, order direction for destruction of intercepted record was not received by the CBI from any such review committee which confirms the legality sanctity of University. They have not said, Your Lordship, that this was placed before the review committee and review committee has approved it or rejected it, Your Lordship. They simply say, Your Lordship, that the review committee, they have not received any communication from review. That will not do. They will have to place material before the learned court below. When the matter was taken up, that yes, this was placed before the review committee as per the mandate of the rule 419A of the Indian Telegraph Rules, Your Lordship. That was not there on the date of consideration of their application. Now they cannot come up, Your Lordship, with a plea that that is there. On the date of consideration of the application, whether these materials were before this honorable, before the learned court below or not, that is the pertinent question in the present case, Your Lordship. And that being not there, Your Lordship, and till date, Your Lordship, they have not come with a specific plea that yes, we have followed the every mandate of the Rule 419A as such, Your Lordship. And in absence of this, Your Lordship, on that ground alone, Your Lordship, this petition, Your Lordship, is liable to be dismissed and set aside. Now, Your Lordship will kindly see their affidavit, Your Lordship, join their affidavit. Your Lordship will find para 83 onwards, Your Lordship. Now, Your Lordship will see that these are the orders. Now, 83. Now, 84, Your Lordship. Ministry of Home Affairs, Your Lordship, Home Secretary to the Government of India, passing an order which, Your Lordship, has a ramifications for a citizen, Your Lordship. His right to privacy is going to be infringed with this by saying that this is the by restricting it to procedure established by law. Your Lordship will kindly see, New Delhi, there is no date on the order. This is how, Your Lordship, order has been passed. There is no date, Your Lordship, in the order by the Home Secretary. Home Secretary is passing an order, Your Lordship, of this nature, Your Lordship, without putting date, Your Lordship. No file numbers, Your Lordship. And each order, Your Lordships, if peruse, Your Lordship, will find that this is the stock orders, Your Lordship. Same words, same wordings, everywhere, Your Lordship. This is not how things are contemplated when Honorable Apex Court passed the judgment in PUCL, Your Lordship. They will have to, will these order reflects application of mind, Your Lordship? Except putting these words, Your Lordship, now therefore I, Union Home Secretary, being satisfied that for reasons of public safety, it is necessary and expeditious so to do, in the interest of public order for preventing incitement of commission of an offence, hereby direct that any telephonic message relating to clandestine conduct so and so be intercepted and disclosed to Director CBI. Your Lordship. Everywhere this is the order. What are the basis? Where from that finding objective material, where are those? Is it reflected from the order? It's a general order passed, it is prepared, signed, and therefore, Your Lordship, the non-application of mine is reflected from the fact that they have not put even date in this particular order. This is page 84, Your Lordship will get, then Your Lordship will get page 87, order by the Secretary Government of India Ministry of Home without any date. Then page 89, Your Lordship. These the way the order has been passed, Your Lordship, that itself reflects that there is, firstly, there is no application of mine, and secondly, Your Lordship, there is a possibility that these are all afterthoughts and prepared, Your Lordship, belatedly, just to bring to the record the fact that, Your Lordship, they have followed semblance of procedure in this particular case, Your Lordship. Therefore, Your Lordship, the materials they have brought before this Honorable Court by way of an additional affidavit, the orders passed by the Home Secretary and the Director, Your Lordship will find that these are devoid of the material facts. They don't disclose application of proper mind by the concerned officer, and therefore this cannot be taken into consideration. This cannot be considered as per the mandate of the Rule 419A of the Indian Telegraph Rules, Your Lordship. And in fact, Your Lordship, if Your Lordship go through their averments in their petitions, both in their pleadings, Your Lordship, both in the criminal petition as well as in the affidavit, rejoinder affidavit, Your Lordship, will find so far as these two aspects are concerned, public safety and the emergency, there is no mention about that, Your Lordship. There is no mention how it can be considered as a public safety, a public issue of public safety and public emergency, except in the rejoinder affidavit they have made reference to certain judgments of the Honorable Apex Court. By saying so, they try to impress upon this Honorable Court that these are on the basis of the, since it is against the corruption, therefore public safety is involved. Now if Your Lordship take up this particular act, Your Lordship will find section 5A, Your Lordship, section 5. Your Lordship got it. Power for government to take possession of licensed telegraph pen on the occurrence of any public emergency or in the interest of public safety, the central government or the state government or any other officer especially authorized in this behalf by the central government or the state government may, if satisfied that if it is necessary or expedient to do so, take temporary possession for so long as public emergency exists and the interest of public safety requires the taking of such actions of any telegraph established, maintained or worked by any person licensed under this Act. On the occurrence of any public emergency or in the interest of public safety, the central government or the state government or any officer especially authorized in this behalf by the central government or the state government may, if satisfied that it is necessary or expedient so to do, in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with the foreign states, or public order, or for preventing incitement to the commission of an offence, for reasons to be recorded in writing. By order, direct that any message or class of messages to or from any person or class of persons or relating to any particular subject brought for transmission by, transmitted, or received by any telegraph shall be transmitted or shall be intercepted or detained, or shall be disclosed to the government, making the order or officer thereof mention in the order. Now, your lordship will kindly note, your lordship, apart from the fact that under what circumstances they can intercept, it clearly mentions that reasons to be recorded in writing, your lordship. Can we get these reasons, your lordship, from the order placed before this honorable court by the CBI, your lordship? When it says that reasons to be recorded, then your lordship, there will have to be some materials before the concerned officer, and he will have to go through, and that he has gone through these particular materials, that must be reflected in the order itself. Only then we can say that provisions of Rule 5.2 has been complied with. And since it involves the infringement of fundamental right, therefore the Honorable Apex Court has held that the procedural safeguard will have to be followed scrupulously. And therefore your lordship may kindly look into the PUCL judgment, your lordship. Which is the basis of this rules, your lordship. And interestingly, your lordship, these orders, your lordship will find, when they have filed the petition, they could have annexed these orders in the petition itself, your lordship. They did not, your lordship. And they have come up with these orders at a belated stage when, your lordship, the rejoinder has been filed. We have filed our affidavit long back, your lordship. So these are also, your lordship, relevant facts, your lordship. Para 28, your lordship, of this judgment, your lordship. May I read, your lordship? Section 5.2 of the Act permits the interception of messages in accordance with the provisions of the said section. Occurrence of any public emergency or in the interest of public safety are the sine qua non for the application of the provisions of Section 5.2 of the Act. Unless a public emergency has occurred or the interest of public safety demands, the authorities have no jurisdiction to exercise the powers under the said section. Public emergency would mean the prevailing of a sudden condition or state of affairs affecting the people at large, calling for immediate action. The expression public safety means the state or condition of freedom from danger or risk for the people at large. When either of these two conditions are not in existence, the central government or a state government or the authorized officer cannot resort to telephone tapping, even though there is a satisfaction that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, etc. In other words, even if the central government is satisfied that it is necessary or expedient so to do in the interest of sovereignty and integrity of India, or the security of the state, or friendly relation with sovereign states, or public order, or preventing incitement to the commission of an offence, it cannot intercept messages or resort to telephone tapping unless public emergency has occurred, or the interest of public safety, or the existence of interest of public safety requires. Neither the occurrence of public emergency nor the interest of public safety are secretive conditions or situations. Either of the situations would be apparent to a reasonable persons. The first step under Section 5.2 of the Act, therefore, is the occurrence of any public emergency or the existence of a public safety interest. Thereafter, the competent authority under Section 5.2 of the Act is empowered to pass an order of interceptions after recording the satisfaction that it is necessary to expedient to do so in the interest of so-and-so, so-and-so. When any of the 5 situations mentioned above to the satisfaction of the competent authority required, then the said authority may pass the order of interception of messages by recording reasons in writing for doing so, your lordship. Again, your lordship, that has been it has been clarified by the Honorable Apex Court, the recording of reasons. The above analysis of Section 5.2 of the Act shows that so far as the power to intercept messages conversation is concerned, the section clearly lays down the situation condition under which it can be exercised. but the substantive law as laid down in section 5(2) of the Act must have procedural backing so that the exercise of power is fair and reasonable. This is said procedure itself must be just, fair and reasonable. It has been settled by this court in Maneka Gandhi versus Union of India that procedure which deals with the modalities of regulating, restricting or even rejecting a fundamental right falling within Article 21 has to be fair, not foolish, carefully designed to effectuate, not to subvert the substantive right itself. Thus understood, procedure must rule out anything arbitrary, freakish or bizarre. A valuable constitutional right can be canonized only by civilized process. This is the reason why, Your Lordship, the question of Your Lordship, following the mandate of 419, scrupulous following of the mandate of 419 arises, Your Lordship. In the context of this, Your Lordship, when this fiducial judgment was passed, Your Lordship, till then, Your Lordship, right to privacy has not been considered as a fundamental right by the apex court, Your Lordship. It was only when in 2017 Putkusami judgment came, Your Lordship, it was recognized as a fundamental right, Your Lordship, right to privacy. In that view of the matter, Your Lordship, the importance of the procedure mandated by Rule 419A becomes more important, Your Lordship. Then Your Lordship will kindly, there is another judgment on this public safety, Your Lordship. What will constitute, Your Lordship, in Hukum Sandhu? Your Lordship, the Vinit Kumar judgment that has been relied on by the Garnet court below, Your Lordship will find. Before that, Your Lordship may kindly take up this Hukum Sandhu. Para 13, Your Lordship. Married, Your Lordship. Section 5(1), if properly construed, does not confer unguided and unbridled power on the central government, state government, especially authorized officer to take possession of any telegraph. Firstly, the occurrence of a public emergency is the sine qua non for the exercise of power under these sections. As a preliminary step to the exercise of further jurisdiction under this section, the government or the authority concerned must record its satisfaction as to the existence of such an emergency. Further, the existence of the emergency, which is a prerequisite for exercise of power under section, must be a public emergency, not any other kind of emergency. The expression public emergency has not been defined in the statute, but contours broadly delineating its scope and features are discernible from the section, which has to be read as a whole. In subsection 1, the phrase occurrence of any public emergency is connected with and is immediately followed the phrase or in the interest of the public safety. These two phrases appear to take color from each other. In the first part of subsection 2, those two phrases again occur in association with each other, and the context further clarifies with implications that a public emergency within the contemplation of this section is one which raises problems concerning the interest of public safety, the sovereignty and integrity of India, the security of the state, friendly relation with foreign state, or public order, or the prevention of incitement to the commission of an offence. It is in the context of these matters that the appropriate authority has to form an opinion with regard to the occurrence of a public emergency, with a view to taking further action under these sections. Economic emergency is not one of those matters expressly mentioned in the statute. Mere economic, this is not required. Now, Your Lordship, if Your Lordship look at this, Your Lordship will find that the public emergency and public safety cannot be, Your Lordship, taken isolatedly, Your Lordship. It is interconnected. And therefore, and if we go through their pleadings, Your Lordship, will find they have tried to, Your Lordship, bring public safety out of this public emergency, which Honorable Apex Court has clearly said that that cannot be done. It is these two words, those two phrases are used along with each other, and this has link with each other. Therefore, from the perusal of the pleadings, from the perusal of the order passed by the Home Secretary, it becomes palpable that they have not been able to show any public emergency or public safety connected with the public emergency. Therefore, in my humble submission on that ground also, Your Lordship, this order, so far as the order of the learned court below is concerned, is required to be upheld by this Honorable Court, Your Lordship. Then para 18, Your Lordship, of this judgment. It is well settled that where a power is required to be exercised by a certain authority in a certain way, it should be exercised in that manner or not at all, and all other modes of performance are necessarily forbidden. It has been, Your Lordship, in the context of Section 5 of the Indian Telegraph Act. It is all the more necessary to observe this rule where power is of a drastic nature and is exercised in a mode other than the one provided will be violative of the fundamental principles of natural justice, Your Lordship. Now, in the present case, the telephones of the appellants were to be, this is not required. But, Your Lordship, that this court, while deciding an issue relating to Section 5(2) of the 5 of the Indian Telegraph Act, has clearly held that the procedure laid down will have to be followed, and the manner prescribed will have to be followed. Since procedure has been laid down, you will have to go by that procedure and mandatorily follow it, since the provisions are very stringent in nature. Now in Vinit Kumar, Your Lordship, though Vinit Kumar judgment has been stayed by the Honorable Apex Court, Your Lordship, there are other judgments also, one from Delhi High Court as has been placed before this Honorable Court by my friend, Your Lordship. And secondly, Your Lordship, there is a judgment from Rajasthan High Court also, Your Lordship. It's a very recent, Your Lordship, wherein also it has been held that, Your Lordship, if telephonic conversation is, Your Lordship, intercepted in violation of the Rule 419A, then, Your Lordship, it will be considered as bad in law and will liable to be quashed, Your Lordship. Now, Your Lordship, with that judgment I am placing, Your Lordship, before Vinit Kumar, Your Lordship. This is 2023 SCC online, Rajasthan 1108, Your Lordship. Para 14, Your Lordship. Para 4 first, Your Lordship. The challenge is on the ground that the right to privacy has been infringed by putting the mobile phones of the petitioner and others on surveillance spying by the state machinery. The orders are violative of Article 1921 of the Constitution of India unless the same is consistent with the procedure established by law. In the case on hand, no reason for making of such order is disclosed, rather are on the teeth of the procedural requirement. Then Your Lordship will get the orders, Your Lordship. In the next page, Your Lordship, order by the Home Secretary of the state. Then Your Lordship may kindly come to paragraph 8, Your Lordship. Submission of the petitioner. Mr. S.S. Hora, learned counsel for the petitioner, contends that in People's Union for Civil Liberties versus Union of India reported in 1997 1 SS 301, the Honorable Supreme Court considered the opposite provision of Section 5(2) of the Indian Telegraph Act and held that the conditions, situations of public emergency or the interest of public safety are not secretive conditions. The situation should be apparent to a reasonable person. In the case on hand, none of the impugned orders depict that what were the situation which persuaded the authority to record the public safety requires such an order. Only bald statement of public safety involved would not suffice the compliance of law. Moreover, the authority has to record reasons in writing before the permitting interception of the all details. Now, Your Lordship will kindly come to para 14, the finding of the Honourable Court, Your Lordship. Learned counsel for the petitioner next contends that the respondent authorities have acted in utter violation of the requirement of procedural safeguard under Rule 419A, Supra. Mr. N.L. Meena, the secretary, was not competent person to pass order under Act. Rather, Mr. Abhay Kumar, principal secretary, Home, was the competent authority. In fact, N.L. Meena and two other secretaries were working under the principal secretary, Home. And learned counsel next contends that as required by the rules, the order should have been transmitted to the duly constituted review committee for its approval, which has not been done in the case. It is not the case of the respondent that they have opted for invoking suspension clause in unavoidable circumstances as mentioned in the said rules. Then, Your Lordship, the reference to the rule, and then para 17. I find force in the submission of learned counsel for the petitioner that the impugned orders have never been sent to the review committee, which ought to have been sent with the statutory period, and the review committee was also expected to take decision on the validity of the impugned orders within a specified period. The statutory provisions are for some purposes and not for fun. The aforesaid provisions ought to have been strictly followed but has not been followed at all. The respondents have not controverted that the impugned orders were not sent to the review committee, nor any material suggests that the impugned orders are sent to the review committee. The impugned orders do not contain any reason, whereas the statutory provisions requires reasons to be recorded in writing for coming to the conclusion that the interest of public safety has persuaded the authority to pass the impugned order. Then para 20, Your Lordship, when the statute provides procedural safeguard to prevent arbitrary infringement of right of privacy, it must be strictly followed. In other words, required mandates could not have been ignored or superseded by the state or its machinery, leading to offend the right under Article 1921 of the Constitution of India. If the direction of the Honourable Supreme Court in PUCL case, which has been reinforced and approved by the Honourable Apex Court in Puttusame's case, as well as mandate of acts and rules are allowed to be flouted to affect illegal interception of messages, it would lead to breeding contempt and arbitrariness. In view of the above discussion made, it would be evident that the impugned orders suffer from manifest arbitrariness, and if allowed to stand would amount to permit violation of fundamental rights of citizens in law laid down by the Supreme Court. Therefore, all the three interceptions ordered challenged herein and referred above stand hereby quashed. The respondent authorities are directed to destroy the intercepted messages, recording and its copies. Such messages shall not be considered in the pending criminal proceeding. At any stage of the proceeding, the petitioner would be at liberty to adopt available legal remedy for other relief sought for in the writ. Now, very clearly, Your Lordship, the Honourable, and this has been, in fact, Your Lordship, in 2006 itself, Andhra Pradesh High Court has also held that if it is in violation of the post-PUCL judgment, Your Lordship, if it is in violation of the 419, then the interception will have to go. Cannot be. Therefore, in my humble submission, Your Lordship, the learned court below has not committed any error in passing the impugned order. And if Your Lordship kindly take up Binit Kumar for last judgment, Your Lordship, I am showing Your Lordship. It has discussed everything, Your Lordship. The dedication Binit Kumar. That's the Lordship. Your Lordship, para 8, Your Lordship, after referring to PUCL judgment, Your Lordship, para 8, the proposition that illegal tapping of telephone conversation violates right to privacy is now accepted and reinforced as guaranteed fundamental right under Article 21 of the Constitution of India by a 9-judge Constitution bench decision in case Puttusame versus Union of India. By overruling the earlier Constitution bench judgment, which did not consider right to privacy as a fundamental right, analogous to American Fourth Amendment, MP Sharma versus Satish Chandra, or held that invasion of privacy is not an infringement of fundamental right as guaranteed under Constitution of India in Kharak Singh versus so and so. It has now been held by the Constitution bench in case Puttuswamy that the right to privacy is protected by the Constitution as an intrinsic part of the right to life and personal liberty under Article 21 of the Constitution of India and as a part of the freedom guaranteed under Part 3 of the Constitution of India. Moreover, the view taken in PUCL case was affirmed by the said 9-judge bench in K. Puttuswamy with following observation. Your Lordship, there is a reference to that. Then Your Lordship, I will not. Your Lordship, in Puttuswamy there is a reference, Your Lordship, of this. Your Lordship will get it in para 12, Your Lordship. Para 12, Your Lordship. Then Your Lordship may kindly come to para 13, just above that, Your Lordship. Lordship, this 638, Your Lordship. Now therefore, Your Lordship, the orders, even if we assume that they are there for interception of our telephonic conversation, Your Lordship, this has no sanction of law, Your Lordship. And in absence of lack of sanction of law, Your Lordship, this order cannot be considered as a valid order, and these orders are non-est, Your Lordship. And the learned court below, Your Lordship, rightly taken note of the state fact that the mandate of 419 has not been followed, and therefore and one more point, Your Lordship, that in respect of telephone number 961226655, Your Lordship, Lordship, that will be in Your Lordship will get, if after in page 91 of the affidavit, Your Lordship. Your Lordship will find that Your Lordship, this order 91 no honey. Lordship. Unto 90. That, Your Lordship, I have not got it right now, Your Lordship. But otherwise, Your Lordship, my submission is that, Your Lordship, in view of what I have submitted, Your Lordship, that this criminal petition is liable to be dismissed on the ground of merit, as well as, Your Lordship, on preliminary point of Your Lordship, limitation, Your Lordship. This
Yes, well, I'll be very cryptic, my lord. Two, my lord. 3 and 4, my lord. Item number 6, my lord.
I am for 1. I am 1.
Item 6 and 7.
My lord. Respondent 3 and 4, my lord. My lord.
Further investigation is going on, my lord, so it is relevant. Further investigation is continuing, my lord. No, my lord. We were not arraigned as accused at the moment, my lord. But further investigation or what would be the fate, my lord. So it survives, my lord, the application. 6, my lord, for respondent number 3 and 4, my lord.
7, 5 and 6. 5 and 6.
And 7, my lord, for respondent and 2 I am there. In 7.
And I am also there.
Oh, so my senior friend is there.
In item number 7. Respondent number 3 and 4. And my friend Mr. And so my lord would continue with the matter today or?
My lord.
All right.
Yes.
Now.
My lord, my lord.
Yes.
My lord. My lord. Thereafter, my lord. Highly obliged.
Fix on 29th of this month, because there is a scanned copy of the record and everything. My lord, 36, my lord. Record is there, everything is there. 29, my lord. Then it is possible on, my lord. If it is not possible 29, then 30, my lord. 30. First week of June. Then, my lord, on 4th of June, my lord.
Lordship, item 29, that IA has come up for suspension of sentence. It may take some time, Lordship. First week of June, it may be fixed, Lordship. Today, it may not reach, Lordship. 29, Lordship. 4th of June, Lordship. 7th of June. Obliged.
Lordship, in regarding item number 8, Lordship, with the consent of other party, Lordship, that matter may be taken up on the first week of June, Lordship, because today the matter may not reach, Lordship. Of that, 6th June, Lordship.
May I please, Your Lordship, item number 30 maybe pass over for 30. I am for the petitioner, Your Lordship. Yes, sir.
My lord, I take item number 37, my lord. But there is too much urgency, my lord, and my senior HR Chaudhary will argue, my lord. Let the matter picked on Monday, my lord. And we custody. My lord, they will be then Tuesday, my lord. Other will out of station after Tuesday. Tuesday, my lord. Other HR Chaudhary will out of station after Tuesday. Tuesday, my lord. At least Tuesday, otherwise it will be very.
It's for order.
29, sir, lots of matters are there.
29, my lord, no, 27, 28. No, it will be on 28. 28.
Okay, we are giving you, but I don't know. It may not be because already lots of matters have been.
Yes, your lord.
Hello,
All 15, 16, 17, 18.
Yes, 16, 17 and 18.
Yes,
Just 15 and 16, do you have any instruction?
Yes, no, actually, case taken by the Session Judge Morigaon, and it is not returned. Because of that, I was given a report in WhatsApp, kept in
Morrigan session there. Several other persons because of that.
No, that is there. The CD is pending before section just
But first it also not.
Otherwise, in regards to statute, is there any from the IO that within 2 days?
My lord,
within 5 days?
I have not personally talked, but they are these are the main person, my lord. 15 and 16. Otherwise, only length of business, 82 days under custody.
That's why I'm asking 82 days in length of business, so 8 more days are there, or can to complete
My
this
lord,
statutory period.
that is also
Within 6-7 days, within 4-5 days, if it is possible for the IO to file that, then it's okay. We'll keep it. Or is it not possible?
that information is not given, but because I telephonically not contacted, my lord, our office has given them only the report, my lord. That we have not given the city because
In the
of
morning
this.
hours, I just asked.
No, my lord, yes, I not got any telephone, my lord. Our office is contacted, my lord, because of that, my lord. Regarding whether it can be within 8 days, whether suspect can be or not.
When it be Monday, will be how many days then? For Monday?
Monday, today is
Lordship, on the last occasion, so Lordship, after using the CD, Lordship, your Lordship fixed the case for 2 days, Lordship. On the last occasion, so Lordship,
even Friday, my lord, that instruction we can it can be questioned on Friday. If possible, my lord.
your Lordship, on the last occasion, had the matter at length, Lordship, and fixed the case, since you are on the last date occasions, Lordship, your Lordship consider that some days further custody is required. Accordingly, fixed the case today, Lordship. And so many co-accused already released on bail. We are in 82 days, Lordship. On the, we have not, on merits, Lordship, on the length of detention, Lordship, we may be allowed on bail. 82 days, Lordship.
Otherwise, all allegations against these are the two main.
These two are the main.
Yes.
Imposing any conditions, Lordship, 82 days, length may be considered.
On the 24, it will be on to 84 days. Monday, 85,
And
87, Monday will be 87 days.
And
because what I'm saying, there are lots of, the
yes,
accused
materials,
persons.
huge materials.
The involvement is different involvement are different in connection with this case. Some are uploading the unloading the Arakanats somewhere, receiving the Arakanats somewhere, purchasing the Arakanats, some are bona fide purchasers, some are directly involved. So there are categories of the accused persons in fact.
That questions already we have discussed also on the last occasions, Lordship.
Yes, that's
accordingly,
why
your Lordship
but
fixed
as
that
per
case.
his submission, these are the main two accused.
They have projected, Lordship. In this case, we are as a prime accused, Lordship.
You are the prime.
But nothing has been recovered from the in item number so far. Item number 15 is concerned, Lordship. Nothing has been recovered from our possession.
It won't be recoverable because you are the
That
hijacker.
truck was hijacked in
You are
another
the
place
hijacker.
subsequently.
Lordship, one Ekapor Ali, out of the same forwarding report, he was one of the persons, Lordship.
Hijacker.
Hijacker. He is released on bail on 59 days for that, Lordship.
89 days.
59 days.
59 days.
Yes. 59 days. So many cases
I don't know
already
how
released on bail,
it is
Lordship.
that I don't know.
Forwarding report, page 17. Ekabor Aleva, 3.
Issue, on last occasion, I am only on length of detention, Lordship. It is some relaxation, Lordship. We are praying, Lordship. 7-8 days, Lordship. Tomorrow is also holiday. Ultimately, Lordship, he will release on next day.
But other two cases, they are on interim. Let the city may come. That.
Is one of the material I put this number of since when they are behind the bar? Today, the calculation.
1/3, first March 24.
Okay, right. 17 and 18, you are on the both the petitioners are interim. I mean 17 who is appearing.
17, not.
He is on interim.
17, 18, both are in interim, my lord.
And they are also interim.
Yes, it is not that may be extended, my lord.
Quite then.
First week of June. June or 6th of June.
6th of June. Would be matter will be on 6th of June.
Not.
Interim will be extended.
Published.
CD has been performed.
CD is there.
The FIR is page 13. Ma'am.
Page
13. There is an allegation of there is a matter of fight between the police and the public. He is a witness to the incident, brother, because his house is nearby.
So there are as many as how many? I mean accused persons 24, 20.
There are many accused persons, brother, because
you are accused number?
Public, I am accused number minus 12.
Total 24.
You are 12, huh?
There is altercation between the public and the police matter. And I think FIR has been exaggerated statement has been made as because police on the other side and general public on the other side, madam.
So Fees
I
Rule
don't
7
know.
is also there.
My lord?
Fees Rule 7 is also there.
He is 7, man. That's what I said, man. He's exaggerated FIR, my lord. Because police on the other side, my lord. And I don't know what is the involvement of the accused in this case, my lord.
Yes,
my lord, there was an accident and police went to rescue that one person got injured, my lord. And when the police went to the place for occurrence, my lord, some villagers and nearby person were together, my lord, and they assaulted 3 police personnel actually. But as per the injury report, my lord, 2 police person, the abrasion 3-4 injury, 1 police person got 4 injury, and 1 is 3 injury. all are but simple and by blunt object. They have been assaulted by hand and fist and by small branches of tree. All three. And there are other people around 24. The witness police person they gave witness statement as per their statement total 24%. All the petitioners, all the accused. And his name is one of the accused. He is one of the accused.
So his FINM accused, is involvement, is any
involvement?
involvement?
Direct, all the not specific. That these all are involved in hand and fist and with small bunches of tree assaulted the police. And
that's the altercation took place, but that halla and all that.
It's
that
not
is
like
not
that. Not injury. They took the law in their hand and attacked the police. And two police personnel got injury. Maybe simple, but one got 4 injury, back, forearm, trauma, and throat. This is also throat. One is got 3 injury, one is all are simple by blood object. Assault is there, and both the witnesses took the name of all the persons. A few persons earlier got bail. That is another thing. But involvement is not.
They have been granted bail because this. What I've seen from heard from my learned friend, but this is normal, my lord. It happened because there is no specific allegation against the person, by a present accused person. And here I say that, my lord, the paragraph 9 I said specifically that his house was nearby, so he was a witness to the incident.
But it's not like that. Only altercation took place. Maybe simple injury, but injuries are there. Not on one injury, one got 4 injury, one got 3 injury. Injuries are there, man.
Lordship will grant me, my lord. Otherwise, I will be evading arrest, my lord, because police is asking me. Gitali Fugat.
Gitali Fugat. Also had AK Prat. The fact that there was a the and now you only and not got however somehow the however the name of the body his name is he is the boy by the fact that against the present but the name of and it will percent of the file final dictated by plan caused by plan. However, okay, will be
But
there will be some condition.
Yes. Not repeat some such type of activity in future.
Yes, those conditions will be allowed. There will be some direction appear before the IO within 7 days.
Well, obliged.
But the rest of the matters, Lordship, because 6, 7, I think will take some time.
Will take all the time. Up to 4, 15, 16.
We'll
rest
wait.
of the matter most probably may not reach. May, I don't know. It's subject to the
time they take.
Time. But obviously it will take some time. I think.
It will take some time. Because there are so many councils there.
Some of them have already completed.
I beg to mention my item number 12, my lord. Lordship may kindly fix it on 24th, my lord. Very urgent matter, my lord. Lower court case is fixed on 28th, my lord.
24 I can pick, but there are, we have just, most probably it will be declared as a holiday by the High Court also.
24th, my lord.
24, probably it is, yeah. If it is fixed on 24, it may, I don't know.
24th is otherwise a restricted holiday.
Restricted holiday.
State holiday is there, but we are
Lordship may
planning.
kindly accommodate on 27th, my lord.
27th, my lord, because they have urgency.
My lord, because lower court case is, my lord, fixed on 28th, my lord.
Okay, 27th.
My lord.
It start from 6 and 7.
6, no? 6, number 3 for my lord, with all respect, my lord, 6 for respondent number 3 and 4, my lord.
6, you are for the respondent number?
3 and 4, my lord.
Not charge it.
Six and 7.
My lord, my lord.
6 or 10.
Full. And for 7, respondent number 2.
No, you are for
Six.
criminal revision 145 or?
Both, my lord. 6, 3 and 4, my lord, respondent number. 7, my lord, respondent number 2, my lord.
In 6, respondent number?
3 and 4, my lord.
3
And 7, respondent number 2, my lord. একেলগে হ'ব
7. So in item number 7, you are for 7.
2, my lord.
Oh, item number 7.
My lord, with all respect, my lord, I'm sorry, my lord, the series end, the repetition would be very bad, my lord. My only respectful prayer is this, my lord, with all respect, my lord. First of all, so far as 6, 3 and 4 are concerned, my lord, when it came up 15 days prior hand, my lord, but fixed it today possibly, after a lot of deliberation, my lord. I said one thing, my lord, no matter how many times you forget it out, it cannot make it work. Because on limitation it goes. Merit is a separate matter, my lord, with all respect, my lord. On limitation it goes, it has been upped number of times by other, my lord, with all respect, my lord. Learned advocates, my lord, they have placed it before your lordships. On the same line it goes. It doesn't survive, my lord. Secondly, my lord, the other counts, my lord, with all respect, my lord. It was, my lord, definitely, my lord, the authorities which, my lord, which is absolutely galloping on the field, my lord, in this domain, my lord, is PUCL and thereafter Puttuswamy, my lord. And PUCL would be, my lord, in Para 28. One thing is absolutely crystal clear, my lord. With all respect, my lord, I'll be very cryptic, my lord. Then Para 28, my lord, just 2 lines, my lord. My lord, I needn't have to read it, my lord. It cannot be secretive, my lord. That Home Ministry, my lord, the impugn order, my lord.
So you are not PUCL?
It's not necessary, my lord. I'll just...
Stay here. Anyway, yes, on which para you are?
My lord, in Para 28 of PUCL, my lord.
Yes.
That is 1997, my lord. At a point of time, my lord, the rules were not framed, my lord. The rules were not framed, my lord. With all respect, my lord, it was 142 directives, my lord. whatever is there in the impugn, not the impugn judgment, my lord, that letter from the Home Ministry, my lord, allowing, my lord, whatever be it, my lord, with all respect, by phone tapping and everything, my lord, with all respect, my lord, it cannot be secretive, my lord. Have I made my question clear, my lord? Public order or public emergency, whatever be it, my lord, it is palpable, my lord, and it is open to, my lord, even a commoner size, my lord, with all respect, my lord, para 28. And that was at that point of time, my lord, because the reason, my lord, in Puttuswamy 2023, my lord, this privacy, my lord, with all respect, I would submit, my lord, is a constitutionally protected right flowing from Article 21. No person shall be deprived of his life and liberty except according to procedure established by law. Meaning thereby, privacy, my lord, because somebody's phone is tapped, privacy is gone, my lord. It can be tapped, provided by following the due process of law. What is the due process of law, my lord? Section 5 of the Telegraph Act. Thereafter, my lord, rules have been framed, my lord, if I am not mistaken, 419, my lord. In this, my lord, with all respect, my lord, I need not have to read PUCL again and again, my lord, re-emphasizing, and thereafter Puttuswamy, my lord. Well, exactly tailor-made cases, my lord, one from Bombay High Court and the other is from Rajasthan High Court, my lord. I'll be very cryptic. I'll read those, my lord. And another aspect, my lord, with all respect, I would submit, my lord. On 3 counts it goes. First of all, it goes, my lord, on the ground of limitation. It doesn't sustain. Merit is besides the point, my lord. And thereafter, my lord, the first prerogatives are, my lord, with all it would be repetition, my lord. I'll be very cryptic, my lord, with all respect, my lord. In this Bombay High Court, my lord, with all respect, my lord, the authority is, I'll name it, my lord, I'll read the lines, my lord, with all respect, my lord. Vineet Kumar, my lord. Well, it has been read many times before your lordships, my lord. I'll take only 2 minutes, my lord. Vineet Kumar is, my lord, with all respect, my lord, exactly tailor-made like us, my lord. There, my lord, if you turn the page, there, my lord, 5-1, my lord. 2 things are very paramount, my lord. First of all, those are to be there. This is those 2 points are the genus, my lord, and the rest are, my lord, with all respect, my lord, specifics, my lord. First of all, my lord, we don't have to read it, my lord, on the occurrence of any public emergency. First, public emergency has to be there, my lord. And thereafter, my lord, or, my lord, in disjunctive form, my lord, with all respect, my lord, public safety, my lord. First of all, those 2 conditions are to be available, either, my lord, public emergency, disjunctive, or public safety, my lord, with all respect and folded hands, my lord. And thereafter, these points are to be, my lord, crystal clear and transparent and, my lord, apparently palpable, my lord. Those are to be there, my lord. Any of them, my lord. It is satisfied that it is necessary or expedient so to do in the interest of, first of all, sovereignty, my lord, and integrity of India. That has to be present. Or, my lord, security of the state, my lord. Thirdly, my lord, friendly relation with foreign countries, my lord. Fourthly, my lord, public order. And fifthly, my lord, for preventing incitement to the commission of an offence for reasons to be recorded in writing, my lord. In PUCL, my lord, that is way back in 1997, my lord. Merely, my lord, writing in the order, public emergency, public safety, and the specifics down below, my lord, undo, my lord. Thereafter, in PUCL time, my lord, with all respect, my lord, 1997, those were 142, Article 142 directives, my lord. Now, my lord, rules have been framed. And rule, my lord, 149, my lord, with all respect, my lord, apart from all these measures, my lord, another aspect, it has to be fulfilled. Only then they can go for phone tapping, my lord. And that is, my lord, with all respect, my lord, all other avenues of finding material. My lord, with all respect, my lord, that 149, my lord, now, my lord, incorporated by way of rules, my lord. In 149, my lord, with all respect, my lord, that will read out, my lord, with all respect, my lord. First of all avenues are to be by the authority who has applied to the Home Ministry for, my lord, with all respect, my lord, tapping the phones, my lord, all avenues are to be first looked into, my lord. And after those being exhausted, my lord, only then they can go for this measure. And this happens because the reason, my lord, with all respect, I would submit, my lord, humbly, my lord, with all respect, my lord, because, my lord, because privacy is a constitutionally protected right flowing from Article 21, my lord, it can only be curtailed by following the due process of law. And due process of law, now, my lord, with all respect, my lord, apart from these ingredients, my lord, is that all avenues are closed, my lord. And that is absolutely, my lord, tailor-made like in the instant case, my lord. It is, my lord, Lordship, this is Vinit Kumar, my lord. There, my lord, Lordship, would kindly have a look at para 13, my lord. Para 13, my lord. It has been quoted from Kuttuswamy, my lord. Para 13, my lord. Lordship has found, my lord, with all respect, my lord. Any infringement of the right to privacy by state authorities will have to meet the following test based on principle of proportionality and legitimacy. The action must be sanctioned by law. The proposed action must be necessary in a democratic society for legitimate aim. The extent of such interference must be proportionate to the need for such interference. 4. There must be procedural guarantees against abuse of such interference, my lord. These are the sine qua non, my lord. And thereafter, my lord, with all respect, my lord, I am reading para 17, my lord. In para 17, my lord, with all respect and full hands, my lord, we are of the view that as per section 5(2) of the Act, an order for interception can be issued on either of the occurrence of any public I'm taking a minute, my lord. Emergency or in the interest of public safety. The impune-free interceptions orders were issued allegedly for the reason of public safety as held in PUCL Supra unless a public emergency has occurred or the interest of public safety demands. The authorities have no jurisdiction to exercise the powers under the said section. The expression public safety as held in PUCL means the state or condition of freedom from danger or risk for the people at large. When either of the two conditions are not in existence, it was impermissible to take resort to telephone tapping. Thereafter, my lord, it was para 20, my lord, leaving aside 3 lines from the top, my lord. The impune-free interceptions orders could not satisfy the test of principles of proportionality and legitimacy. And here also, my lord, that this order is devoid of all these, my lord, principles, my lord, with all respect, my lord. And thereafter, my lord, Rajasthan one, my lord, exactly tailor-made, my lord. Here, my lord, this is Srikant Joshi, my lord. Srikant Joshi, my lord. Here I am reading the order by which the Home Secretary allowed phone tapping, my lord. Tailor-made like this case, my lord. Exactly, my lord. Duplicated or replicated, my lord, with all respect, my lord. May I, in page 3, my lord. Page 3, my lord. Page 3, my lord, with all respect, my lord. I am reading out the order, my lord, by which phone tapping was allowed, my lord. By the, my lord, the authority, that is the Home Secretary, my lord. Now, therefore, I, Secretary Home, Rajasthan, it goes on and on, my lord. And I read the order, with all respect, my lord, not the impune order of the Lanet Court below, my lord. That order by which phone tapping was directed to be carried out by Ministry of Home, my lord. Exactly, my lord, almost, my lord, every word has been replicated or, my lord, duplicated, my lord. At page 83, my lord. If these are read conjointly, my lord, with all respect, my lord, Lordship, kindly have a look at page 83 of the additional affidavit, my lord. I am not reading both, my lord. It is apparent, my lord. They are exactly the same, my lord. Page 3 of this Rajasthan High Court authority, my lord, quoting Kuttuswamy as well as PUCL and Kuttuswamy together, my lord, meaning thereby Article 141, my lord, that was followed, and thereafter this judgment was passed, my lord, quashing this order, my lord, which occurs at page 3, my lord, and this order is exactly the same as is there in page 83, almost the same, word by word, my lord, which occurs in the present case, my lord, at page 83. If it is looked into by way of merit, my lord, despite the fact that the petition doesn't survive because of limitation. That is first of all, my lord. And thereafter this, my lord, this order, my lord, with all respect, occurring at page 83 was quashed by the Rajasthan High Court because it failed the proportionality principles, my lord, with all respect, my lord. Now, my lord, when Article 21 says, my lord, if privacy is to be, my lord, interfered with, my lord, of an individual, of a citizen, my lord, then it can be done only by following the due process of law. And due process of law is what, my lord? Creation of the legislature, my lord. So rules have been framed, my lord. Now, Section 5 is the parent section, my lord, of Telegraph Act. How it is to be done, when it is to be done, my lord. And thereafter, my lord, with all respect, my lord, 419 of the rules, my lord, says clearly, my lord, phone tapping can be allowed on the top of everything, my lord. It can only be carried out only when all other avenues have been exhausted by the agency, my lord. Here, my lord, the Central Bureau of Investigation, my lord, the nomenclature. And now, my lord, with all respect, I will submit, my lord. It is apparent I need not have to read the book. It is there in the authority itself, my lord. Rajasthan High Court authority, my lord, with all respect, my lord. That would be at page 8, my lord. Of page 8 of, my lord, 2023, my lord, Sasikant Joshi, my lord. Lordship has found page 8, my lord. Thereafter, my lord, Roman 1, Roman 2, I go down below. Thereafter 2, my lord, and thereafter 3, my lord. Now, my lord, when, my lord, privacy is to be interfered with, my lord, with all respect, my lord, by following the due process of law, and process of law has been created by the legislature by, my lord, with all respect, my lord, during the time of PUCL, my lord, those were 142 directions article. Now, my lord, it is a law because under Section 5, rules have been framed in the Telegraph Act, and therein in 3 of Rule 419(3), my lord, with all respect, subclause or whatever be the nomenclature, my lord, with all respect, my lord, it can only be carried out if all other avenues are exhausted. Here, my lord, not a whisper, no way, in any document annexed by the CBI, or, my lord, with the case record, my lord, with all respect, I will submit, my lord, 3 has been given a goodbye, and when it has been given a goodbye, my lord, it cannot be done, my lord, phone tapping, my lord, with all respect, my lord, because it can only be curtailed, previously it can only be curtailed by following the due process of law, my lord. I am reading out 3, my lord, with all respect, but that would be, my lord, from the statute book also, my lord, with all respect, my lord, Rule 419(3), my lord. What 3 says, my lord? While issuing directions under sub-rule 1, direction meaning thereby tapping of phones, my lord, the permission given by the Home Ministry, my lord. The officer shall consider possibility of acquiring the necessary information by other means, and the directions under sub-rule 1 shall be issued only when it is not possible to acquire the information, by any other reasonable means. My lord, this is nowhere transparent in the order passed by the Home Ministry or any other order or in any document, meaning thereby of Rule Section 5, Telegraph Act, rules frames thereunder, Rule 419, specifically subclause 3 regarding tapping of phones, while all other avenues are exhausted, only then it can be resorted to, has not been followed. On that count also, my lord, with all respect and folded hands, I would submit, my lord, this order does not sustain, and exactly in a similarly situated case, my lord, which came up before the Rajasthan High Court, my lord, wherein, my lord, PUCL and Puttaswamy have been elaborately, my lord, with all respect, my lord, Puttaswamy and those were discussed, my lord, that occurs at, my lord, with all respect, my lord. I'm parting with this page, my lord, and para 19 I am reading out, my lord, with all respect and folded hands, my lord, of the Rajasthan High Court Authority, my lord. Sub 19, my lord. Sub-rule 3 of Rule 419 capital A recurs that the authority passing any order under Section 5, parenthesis 2 of the Telegraph Act shall consider possibility of acquiring the information by other means, and the direction under sub-rule 1 of tapping phones, my lord, with all respect, my lord, shall be issued only when it is not possible to acquire the information by any other reasonable means. The provisions are explicit enough that authority is bound to disclose in the impugn orders, that other means of acquiring necessary information was resorted to but was not possible. In the case on hand, merely a bold statement has been recorded that acquisition of information is not possible by any other means. Therefore, the statutory provisions of sub-rule 3 has also not been complied with in the instant case and hence quashed, my lord. If I read the order occurring at page 83, my lord, it mentions in para 3, whatever has been stated, exactly tailor-made, like para 19 of the Rajasthan High Court authority, my lord. With all respect, wherein, my lord, the Supreme Court authorities have been exhaustively quoted, my lord. With all respect, my lord. And para 3 I am reading out, my lord. Mechanically, it cannot be done, my lord. It must, my lord, go through the test of proportionality, my lord. With all respect, I will submit, my lord. In para 3, it has been stated, my lord, mechanically, quoting, verbatim, my lord, whatever the Act provides, without following what the Act says that those are to be carried out prior to tapping of the phone, my lord, with all respect, my lord, has not been carried out, my lord. In para 3, it has been stated, I am further satisfied that it is necessary to monitor this telephone as the information cannot be acquired through any other reasonable means. But, my lord, para 19, and what the rule says, my lord, 419, that all avenues have been exhausted. With all respect, my lord, that is to be properly documented and placed on record, my lord. Those have not been done, my lord. On this count also, my lord, with all respect, my lord, the impugn order, not the, my lord, not the order passed by the learned court below, my lord. What I am saying is the order by which the Home Ministry at page 83, my lord, directed that the phone be tapped as if it was in accordance with law, my lord. It doesn't sustain, my lord. With all respect and tolerance, my lord. My lord, so far as we are 70 months, 7 months. My lord, regarding 7, my lord, item number, my lord, respondent number 2, the same argument will follow, my lord. With all respect, my lord.
Coming back to item 6, I'll stick back to what that limitation issue. But I'll hand over a judgment wherein the principles had been laid down in the judgment of April 24, my lords. Limitation Act for a moment, my lords, again. I'll trouble lordship. Being the junior most of this battery of lawyers, my lord, I should take some advantage. My lord, the Limitation Act, section 3. Even though it's very clear, my lord, Limitation Act section 3 should be construed very strictly. Only in case of 5, my lord, there should be some moderation, my lord. My lord will kindly come to the judgment at its page 16. Page 16 of the judgment, it's point number 26. After discussing all the law points, all the judgments in as requires, my lord, this judgment, all these judgments on limitation, my lord, lordship will find the point number 3. Page 16, point, para 26.3. Unless on a harmonious consideration of the provision of the law, as aforesaid, the law laid down by this court is evident that, I'll pause for a moment, my lord. I have demonstrated that they have invariably failed, my lord. Law of limitation is based upon public policy that there should be an end to litigation by forfeiting the right to the remedy rather than right itself. Number 2, my lord, a right or remedy that has not been exercised or availed for a long time must come to an end or cease to exist after a fixed period of time. Number 3, my lord, the provisions of Limitation Act have to be construed differently, such as 3 has to be construed in the strict sense, whereas section 5 has to be construed liberally. My lord, while filing this revision, my lord, they should have stick to rule section 5, sought a condonation, sought leave of the court, then this should have been registered. Even this is reflected in the High Court rules also. Lordship will direct. Yes, my lord. Section 120, page 127, my lord. It says about revision. That's rule number 24. Page 127. Revision, my lord. That's rule 24, my lord. Says, my lord, everything covered under this will be covered by Part C of these rules, my lord. Part C of that chapter, my lord. It Lordship will find Part C at page 125, my lord. Page 125, my lord. Part C, my lord. My lord, will go to, I don't have the book. The concise fact laid there in the procedure is that when these kind of applications are revisions are filed, the registrar has to go through it. If he finds that there is no delay, he can pass it to the process to register it. But if he finds there is delay, he should, my lord, he must proceed, file before the court with a memorandum of appeal. That is appeal under section 5. That there is a delay, condone it, then we can register the revision, my lord. It's a matter of surprise, my lord, without the mandatory, my lord, procedure laid down that the limitation application should have been preferred, my lord. How come this registration, this revision is, my lord, has been, my lord, preferred? I don't know, my lord, registered, my lord. And my seniors have argued and merit too much. I won't repeat those, my lord. Well, I just stick to 397 plus 401 jurisdiction scope, my lord. Admitting this, assuming, keeping aside this, my lord. These have been, because it is their case, my lord, they should show on record of the, only no further evidence can be adduced, my lord. Only the, what is the part of this paper book or the petition has to be there, and they have to demonstrate the perversity of the order on the face of that. They are showing papers upon papers, bundles of papers are being shown, my lord. On the first judgment, I am relying is, my lord, it's a 2018 8 SCC 165, my lord. My lord, come to paragraph 11.
Which one you relying?
My lord?
You are relying on which one?
There are two judgments. One is our High Court, my lord. I am giving the Supreme Court one, my lord.
Yes.
Yes, my lord. It's, my lord, Kishan Rao versus Shankar Gowda.
Fine.
Yes, my lord. It's paragraph 11 of that, my lord. Shall I read out, my lord? It will suffice. It will suffice. My lord, that paragraph 11, my lord, it says, my lord, just because there is another view is possible, my lord, revision should not be allowed automatically. On the face of the records of the petition itself, my lords, they should go for a revision, my lord. Let us settle, my lords. Then Lordship will kindly take up that other judgment, my lord. It's our Guwahati High Court, my lords. My senior friend is related to that, Vallabh Das. It is a case, my lord, that journalist, my lord, Parag Das, it came for revision, and my lord's firm, my lords will see. It's page 17, my lord. 17. Justice Amitav Roy is the author, my lord. He has enunciated certain principles, my lord. It starts. 50 is a paragraph. Subparagraph 5.1. Lordship has got it, page 17. My lord, 50 days, there's a subparagraph, 5.1, my lord. My lord, it will suffice, perhaps I'm just reading for the sake of my satisfaction, my lord. Well, the crucial, I'm speaking about the crucial consensus. There's a sentence starting, my lords. The crucial consensus on the contours of judicial intervention in an exercise of revisional jurisdiction is founded on the doctrine of ex debito justi to correct a manifest illegality or error of procedure resulting in gross and flagrant miscarriage of justice. Various circumstances, illustrative though, have been recognized warranting invocation of revisional nature and condition singularly to achieve this avowed purpose. This jurisdiction, as presidential enjoyment mandate, is not exercisable to character view of a subordinate court based on a perceived erroneous appreciation of evidence suggesting different deductions. Reappreciation of evidence is also barred, and barring exceptional exigencies, resort thereto is prohibited, even if a serious offence may thereby go unpunished. And then the whole paragraphs on 5.1, 5.2, my lords. 57. 57. It should have been 5.7. I think some confusion in the printout is there.
Confusion is there.
Yes. The principles, well, every judgment has been discussed. Now the principle which has been derived. The principle thus judicially propounded to irrefutably restrict and regulate the exercise of revisional jurisdiction contemplated by the court. The utilization thereof is indubitably available to correct gross miscarriage of justice resulting from the manifest illegality and error of procedure, my lord. It is therefore the cause of justice that is paramount determinative of the invocation of the revisional jurisdiction, even qua an order of acquittal in exceptional eventualities, but assuredly to uncompromisingly uphold the same for the administration where the court exists. The judicially enjoined impedimenta that is not absolute in terms but severely restrictive and noticeably limited to the process of scrutiny contemplated vis-a-vis the order impugned, my lords. Since 97 is not appellate, my lord. It's they cannot show documents upon documents. They have to stick to the whatever they have, my lords, annex here to, my lord. On the face of then perversity has to be shown. Otherwise, these are my arguments, my lord. I am just concluding, my lord.
By paying for in item 7.
Item 7.
Item 6 and 7. I am for 3 and 4, no? 3 and 4, respondent in item number 7. Ramesh Goenka and C. Amit Goenka. Ramesh Goenka and Amit Goenka, who are the respondents. They are the accused persons in this case. Now, my lord, your lordship has had the submission. I would not repeat, but sometime I have to make some repetitions and all that in my submission. First of all, in the context of the section 5.2, it says public emergency and public safety. My lord, I'll take my lord first to the first information report that has been annexed. Whether the case in hand at all come within the purview of public emergency and public safety. My lord, those words has been, my lord, in QCL, what is public safety and all those has been, my lord, defined, my lord. I'll come to that, and in Hukumchand also in 1976, that has been dealt with me. What is public emergency and what is public? In 1976, in Hukumchand's case. I'll refer to that. Now, if your lordship will kindly, page 15 of the, my lord, the petition. Information received from a reliable source revealed that during the period 2017-18, Dr. Pratap Suman, Commissioner of Income Tax, Guwahati, with additional charge of Jorhat, has entered into a criminal conspiracy with Sri Pratap Das, Income Tax Officer, Guwahati, Sri Ramesh Goenka, Advocate, Chartered Accountant, and Sri Amit Goenka, Advocate and Chartered Accountant, Guwahati, Suresh Agarwal, Director, so having office at Guwahati and Delhi and unknown others in the presence thereof, Pratap Suman agreed to show undue favour to Sri Suresh Agarwal, Director, Messrs. Wind Power Infra Private Limited by passing favourable order in appeal, arising out of assessments done in respect of one of the cell company of Sri Suresh Agarwal, and for this undue favour being shown, abusing their official position, Dr. Pratap Suman made attempts to obtain illegal gratification to the tune of Rs. 15 lakh. Now, and Pratap Das, so Sri Ramesh Goenka and Sri Amit Goenka, Ramesh Goenka in coalition with Sri Suresh Agarwal is trying to negotiate the bribe amount with Dr. Pratap Suman and obtain favourable orders against payment to bribe 40 lakhs only to be delivered to Sri Ramesh Goenka at Guwahati on 11. My lord, I am not reading the entire. Basic allegation is that there was some conspiracy in between these persons. Pratap Suman will pass some favourable order in favour of Suresh Agarwal in respect of his sale company of wind power and all that. And in that, an amount of rupees 50 lakhs or 40 lakhs, whatever has to be paid to him. That amount was never paid to Pratap Suman. Rather, the CBI's allegation is that money has been transported by Suresh Agarwal to Ramesh Goenka, and it was seized from the custody of Ramesh Goenka. So, in any manner, the demand and payment that has not been completed may not have any now. The case of the prosecution for the CBI is a simpliciter offence committed under the Prevention of Corruption. Whether section 7, 11 or whatever its sections may be, they have put. I am not going to in detail because your Lordship is not required to decide on merit this case. Now, what petition they have filed before the trial court, that is important. Because one thing has been argued, that the learned trial court, when passing the order, did not look into the materials which were placed in the case diary before the trial court and passed the order, and these orders were there. Without going through these orders, the learned trial court has passed the order. In my humble submission, that is not a correct submission made by my learned friend from CBI. Whatever material available at that time in the case diary, because the case diary which they are showing, this is a case diary completing at the time of filing the charge sheet. In the charge sheet, all these documents has been furnished to the accused persons. I am not saying that these documents has not been furnished to the accused persons. While filing the charge sheet, this has been furnished. But at the time of passing of the order on 28 to 2020, in our case it was the order dated 28 to 2020. I'll come to that order. Before that इनका पिटीशन का कॉपी है यहाँ पे, हाँ इनका पिटीशन का कॉपी ना, पेज 40 आप लोग का कॉपी निकाल के रखो, कॉपी कहाँ है ये देखो। May I just take to my lord, page 41. So it's 2-page petition basically. Para 1, para 1, 2, 3. I am not reading. Basically in para 3, the basic allegation that I have already read, that has been incorporated in para 3. Para 4. Based on the complicity of the accused persons surfaced during the investigation, the following 4 persons has been arrested on ISNA and during course of investigation, the above noted case, after recovery of a bribe amount of 40 lakhs from Ramesh Goenka, is handed over by Pranjal Sharma. Now, next page 42. The evidence emerged on record included the recorded conversation between accused persons, para 5 minutes, that is important. In respect to demand of money and means of delivery of money till its recovery, it is therefore essential to obtain the voice samples of the above named arrested accused persons. That the evidence emerged on record included the recorded conversation between the accused persons in respect of demand of money and means of delivery of money till its recovery. It is therefore essential to obtain the voice sample of the above named arrested accused persons for seeking expert opinion. And this regard a prayer was made before your learned court on ISNA, and the same was rejected by your learned court by order dated 19-4 in view of the matter being pending before the Honorable Supreme Court. That now the Honorable Supreme Court in para 6, Ritesh Kumar has been referred, basically, and they say that the court has given the permission, Article 142, that judicial magistrate has the power to record the, to give the permission to record that this prayer before the Honorable Court to pass the order for recording the voice samples of the accused persons as mentioned above and also pass the orders recorded for intro. Now, my Lord will kindly see, not a whisper anywhere that the conversation has been recorded or the whatever conversation was intercepted by obtaining order from the respective authority as required under 5.2 or following the due procedure under 419 capital A, nothing has been stated. No material has been placed at that point. No document was. If everything was available, what was the difficulty for the prosecution to place all these matters along with their application to justify their seeking permission from the London Trial Court to kindly permit in this situation we want that should be permitted to us to record the voice sample so that we can compare with the recorded versions of the accused person. Now, in this case, though, we file objection. Or the objection is not on record. If your Lordship permits me, I can give a copy. Excuse number 14. उनका ही दे दो. कौन अमित कौन का नहीं उनका दो. अरे रमेश कौन का नहीं दो. इनको कॉपी दो इसका. You know?
God, your objection?
No, not annexed. That is in the trial court of the record.
The trial court record is with us.
Trial court has not called
Oh,
because
no,
Lordship is hearing the matter in the admission is.
So this was your objection?
My objection for respondent number 3, 4 and 7, all file almost same. We have taken the plea also that another petition was pending, all that has been already argued by my friend Mr. Srivastava. I am not repeating to that because already the matter was pending before here when this application filed, and thereafter they have withdrawn that criminal revision petition filed before the Honorable Court. Because I am not that paragraph 5 we have made a statement with that regard. Now, in para 8 we have said that reviewing the order, earlier order. I'll go to directly to para 11. Para 11. That the statements made in paragraph 5 of the petition, so and so are not true and correct. However, it is true that the prosecution paid white petition dated 17/4/2000 issued to be 18 for obtaining voice sample was rightly rejected by the Honorable Court while its order dated 19/4 as such similar instant petition with similar filed by the prosecution is not maintainable in law, and as such the Honorable Court has no power and jurisdiction to interfere in a similar petition with similar fair and review its own order dated 19/4/2018, more so when the said order has attained finality. The accused number 3 further states that the recording of the alleged conversation is in clear violation of Section 5(2) of the Indian Telegraph Act 1885 and the rules made therein, and also in violation of the accused fundamental rights guaranteed under Part 3 of the Constitution of India, including a right to privacy, it is submitted that this aspect of the matter is no more a secret. ये है ना, open नहीं है. And in para 18 we said that we have objection in recording. We have not given our consent. Even if the voice sample is given, we have objection, we will not give our consent. Because that now, my Lord, I'll take my Lord to page 46, the impugn order. May I just in the meantime point out one thing. The Ritesh Sinha's case, so in the last ultimate paragraph it has been said that no, since there is no provision anywhere to give a permission to record the voice samples and all that, the Supreme Court has the power under 142 to give it. So it was ultimately granted. But I will just make a small submission in this regard. The Ritesh Sinha was not a case under Section 5(2). Ritesh Sinha was a case where the facts are, I'll just pinpoint if necessary, where I am talking with somebody, I am talking with Mr. Singh. Now Singh recorded my statement. While the conversation was going on, Mr. Singh recorded my conversation. And that was seized by the CBI. And ultimately, to prove that whether it is my voice or not, the voice sample was asked. And that was done. So in Ritesh Sinha, 5(2) was nowhere there. Ritesh Sinha simply says that since there is no provision in any other law, till the Parliament makes law, the Supreme Court under 142 is competent to give the power to the judicial magistrate to give the permit. And in that case also, it was not that by mere asking, the judicial magistrate or trial court will pass an order giving them to record the voice. Now, may I not take this through the entire. My argument before the trial court was that even Ritesh Sinha is a judgment, not in a judgment in person, not judgment in there, that has been rejected by the trial court. I said that it was in the facts of that particular case the judgment was given and not a judgment in them. And my submission was also recorded. Now, Para 9, page 48. Admittedly, the recorded conversation with regard to the voice samples are sought for are by way of intercepted telephonic conversation. In this regard, I have perused the decision of the Honorable Supreme Court in PUCL versus so-and-so, and also I have perused the decision of the Honorable Bombay High Court rendered in Vinit Kumar. Section 5(2) of the Indian Telegraph Act gives with the power to government to intercept messages which provides that such interception could be done only on the occurrence of public emergency or in the interest of public safety. In PUCL case, it has been clarified that public emergency or in the interest of public safety are essential conditions for applying the provisions of 5. While reading PUCL, I'll just highlight that portion. And the absence thereof, the authority would have no jurisdiction to resort to the telephone taking. It has been further explained that these two conditions are not secretive conditions, and occurrence of any of them would be apparent to a reasonable person. After PUCL judgment, several rules have been framed regulating the interception. I have perused rule so and so in case of Vinit Kumar. The Honorable Bombay High Court found that the interceptions were not in accordance with the aforesaid law and principles and were held to be invalid, and the court directed restriction of those regarding and barred the trial court from considering the same in its proceeding, out of which its case has gone to the High Court. In case of Vinit Kumar, it was also held by Honorable High Court Bombay in paragraph 39 to declare that rehouse the fundamental rights in the administration of criminal law. The and would justify the name would amount to declaring that the government authority may violate any directions of the Supreme Court or mandatory statutory rules to secure evidence against its decisions. From the aforesaid discussion, it is clear that the voice samples sought by the investigating authority with regard to intercepted or taped telephonic communication, then the voice sample can be given only if such intercepted conversation have been checking का कब तक मीटिंग का ना कब तक मीटिंग का केस है ना has been duly intercepted as per the prescribed procedure and the principles laid down by the Honorable Supreme Court as discussed and narrated above. It has also to meet the criteria of public emergency and interest of public safety in terms of Section 5(2) of the Telegraph Act and the principles laid down in regard to the same in PUCL. Learned PPCBI has placed before me the case diary and I have perused the relevant portion thereof. As mentioned earlier, with regard to the telephone taking, I have noticed a letter dated 12/4/2018 written by SP CBI SC Kolkata to SOB CBI Guwahati, where it is indicated in paragraph 4 that original copies of the permissions granted by the Union Home Secretary for interception of mobile numbers may be collected from the office of DIG Special Unit, New Delhi. My Lord, what I am trying to pinpoint to my Lord, that when intercepting the phone of the accused person, these orders were not with the authority who were intercepting the relief phone. We collected from the office of DIG Special Unit, New Delhi, because on 12/4, arrest has already been made. Mr. Goenka was arrested, Mr. Amit Goenka was not arrested, and the other persons, even Mr. Pratap Suman was in the evening, he was arrested. So these are the two main persons. The allegation is that his conversations were going on and on. On 12/4, this letter was there in the file, Office of DIG Special New Delhi. Further, on 10/10, a statement of Sri Parvinder Singh, the then Assistant Director, then Union Home Secretary, was recorded and is available in the case diary regarding orders passed by the Union Home Secretary regarding interception of the aforesaid mobile numbers for a period of 60 days. However, in my consideration, the materials that I have produced in the case diary do not indicate, this is very important, as to whether the complete due and proper procedure has been followed with regard to the telephone taping in this case in terms of provisions of Section 5(2) of the Indian Telegraph Act 1985, Rule 409 of the Telegraph Group, and the principles laid down in the Supreme Court. So, the submission that the trial court has not looked into the orders or whatever materials available in the case diary, in my submission, is not correct, and it is very clear from paragraph 13 itself. It said that the materials I have perused, details of materials has not been given, but the materials I have perused. Thus, in this case, in the facts of the case, on the basis of the materials and in view of the above discussion, I come to the opinion that finding that the materials are not adequate to show as to whether the due procedure with regard to telephone taping as required by law has been followed. Secondly, the criteria and principle of public emergency or interest of public safety required for telephone taping as laid down in PUCL case does not apply in this case. So, para 15 says that CBI is unable to pass the test of telephone conversation having been kept in keeping with due provisions of 5(2), the requirement of public emergency and interest of public security, and the principles laid down in this regard by the Honorable Supreme Court in the above case present. In such a situation, since the case, so ultimately, by this order, they reject. So I am at the cost of repetition again saying that it is not true and it is not a correct submission that the Learned Trial Court has not gone into the matter. Whatever placed before though the application filed by the CBI does not speak of anything. They have not stated anything about the orders they have received from the Home Ministry or from the Director of CBI and all. Now, I will, we have a look to the, now in their affidavit, in reply, they have supplied the copy before this Sarnapur. No, I will not read the entire, I will just pinpoint one to my lord. In fact, it has been already pointed out to my lord that just wordings of section 5.2 in verbatim has been put. No reasons has been assigned. I have just shown the FIR, and charge sheet is also part of the affidavit in opposition filed by Mr. Swetap Suman in this case. Entire charge sheet. The entire allegation is that offence has been committed under the Prevention of Corruption Act, either under section 7, 10, 11, 12, whatever it may be. But because they were trying to give an undue influence, and they want to, there was a conspiracy to give bribe to Swetap Suman so that he can pass an order in favor of Mr. Suresh Agarwal's company of Wind Power now. So nothing relates to public emergency, nothing relates to public safety. Because first this test has to be passed. The second test, there are 5 other tests. Now, may I just take to my lord. Page 80 of rejoinder affidavit by CBI. Page 80 में लो. Annexure 1, page 80. From page 80 to page 87, 8 orders है ना? 8 orders are there. कितने orders है देखो? 8 orders है. I have got it, madam. Page 80. I am just not reading. Your lordship will find. First part I am skipping. That given I have been authorized to exercise. Now therefore I, Union Home Secretary, being satisfied that for reasons of public safety, it is necessary and expedient to do in the interest of public order and for preventing incitement to the commission of offence, hereby direct that any telephone message or the word telephone message is not used. I'll come to the Telegraph Act. My lord will kindly just have a look. Telegraph Act section. Section 3, subsection 3 also. Message has been defined. Message means any communication sent by telegraph or given to a telegraph officer to be sent by telegraph or to be delivered. I am just trying to make out a case here. Whether at all interception of telephone call will come within the purview of 5.2. Because in 5.2, under certain situations, they have given the authority that you can do it. But whether the inception of telephone call, whether telegraph has been also defined in 1 capital AA 1 capital double A, telegraph means any appliances, instrument, materials or apparatus used or capable of use of transmission or reception of signs, signals, writings, images and sounds or intelligence of any nature of wire, visual or other electronic, magnetic, radio waves and Hertzian waves, galvanic, electric and magnetic means. Then explanation is given in what is radio waves and other things. This is one aspect of the matter. Secondly, relating to clandestine contact, movement, activity, etc. Clandestine contact, movement. What they were directed to intercept the messages regarding their clandestine contact, movement, etc. To and from this shall be intercepted and disclosed to Director CBI. Now, all the orders, file number is given the same number. Order same number has been given in all it. None of the dates are typed. All are handwritten.
In some orders, they are missing. Huh? In some orders, the date is missing.
What?
In other case, the date is.
In our case, not.
Here, everyone is in handwritten.
Okay. And then here is the type one. Whichever date you, what I am trying to give a message, that whatever date you feel convenient, you put it. Put it for your ear. Put it. Now, these are the orders from page 82, 87, and the wordings and everything are exactly same. Only the number, telephone number, and they have said, I further satisfied that it is necessary to monitor this telephone as the information cannot be acquired through any other reasonable. About your Lordship will see the number also, 14397 CBI. The orders were passed in 2018. Now, I'll take my Lord to page 88. So, these are the orders by the Home Minister, Ministry of Home Affairs, Secretary to the Government of India, Ministry of Home Affairs. Now, from page 88 to page 92, all are the orders passed by the Director, Central Bureau of Investigation. Well, I am just stressing the fact that I will not show the law. सब एक ही है क्या सर? Wording सब एक ही है. 88. Whereas as per the provisions of sub-rule 1 of Rule 419A of the Indian Telegraph notified on ISNA, framed in exercise of power conferred on so-and-so, the head or second senior most officer of the law enforcement agency at central level is authorized to approve interception of messages for operational reasons. My Lord will kindly see for operational reasons. In emergent cases where obtaining prior permission of competent authority is not feasible. So this is important. The operational region is very important. CBI agency is not only making an investigation and prosecuting persons so far the PC Act is concerned. They have to look the other years. So for that purpose probably they may, because sovereignty of state, integrity of India and everything is involved in type 2. Now therefore I direct the Central Bureau of Investigation being satisfied that for reasons of public safety it is necessary expedient to so in the interest of public order and for preventing incitement of the commission of offence and considering that obtaining prior permission of competent authority is not feasible. But I do not know why it is not feasible. The man is sitting in New Delhi. The director is sitting in New Delhi. He says that it is not feasible. Or the home, the secretariat, home ministry is in New Delhi. Director is sitting in Delhi. Prime Provincial Company Authority is not feasible hereby. Direct that any telephone message relating to calendar sign, same wording, any telephone message relating to calendar sign, contact, movement, activity, etc. from so and so and so, transmitted shall be intercepted and disclosed to the Director, Central Bureau of Interest. I am further satisfied that it is necessary to monitor the telephone as the information cannot be acquired for any other reasonable reason. This order shall remain in force for a period of not exceeding 7 days working days from the date of issue. Now, the same thing in all of the other orders. All these orders were passed. Basically, in all these cases, if necessary, I'll give a chart to my Lord, that today I am not having a copy. 3 days prior to the orders given by the Ministry of Home Affairs for intercepting the messages of the telephone numbers in question. No. Amendment. There is some amendment in 2014 also, so I am giving the latest copy also. But I am just coming to first page 52. First I am coming to page 52. One of the notification of 2007, at page 52 in the similar petition of GCBA. Page 52. Criminal petition filed by the CBA. I am not reading that, I have given that. अपने वाला देखा जो criminal petition 312 of 2020.
Page number 52.
हाँ, page number 52.
No, page number 52, I think.
नहीं
40 or something.
Criminal petition. Petition number 312 of 2020, in which I am arguing.
Yes. Okay, page number 50?
52.
Ah, yes. Yes.
So, three changes असे तो minority पर cover करा some changes जो आपको 14 जाएंगे. Now, after the PUCL case, this rule was framed. I am not reading the entire. First part, Secretary of the Government of India, Ministry of Home Affairs has been given the power. Then, in unavoidable circumstances, such order may be made by an officer not below the rank of Joint Secretary of the Government of Assam. Now, provided in emergent cases, the remote area, in remote area, my lord will kindly consider this is very important. The phone taping has to be done. At Kolkata they have done probably. The person, Mr. Pratap Sumaniji was in Noida and all that. Ramesh Goenka was in Guwahati. So it is not a remote area which the director writes that is not feasible. In remote areas where obtaining of prior direction for interception of messages or class of messages is not feasible, or for operational reasons where obtaining of prior directions for interception of messages or class of messages is not feasible. No operational reason has been given. This is first aspect of the matter. Second aspect of the matter, my lord, down below, the required interception of any message or class of messages shall be carried out with the prior approval of the head or second senior most officer of the authorized officer. Authorized we have not below the rank of Inspector General of Police at the state level, but the concerned competent authority. My lord, this is important. The concerned competent authority shall be informed of such interceptions by the approving authority. Concerned authority is the Secretary, Ministry of Home Affairs. The approving authority is the director in this case. Concerned competent authority within a period of 7 working days. If the confirmation from the competent authority is not received, I am on basically on this, not received within the stipulated 7 days, such interception shall cease and the same message or class of message shall not be intercepted thereafter without the prior approval of the Indian Home Secretary or the State Home Secretary as the case may be. Now, if your Lordship kindly again turn to page 80. Page 80 of here, rejoinder of the CBI. My lord will kindly see no whisper. No whisper with regard to any confirmation from the competent authority as regards the order given by the director either on 6th or any other date that has been already announced. Now, in all the orders of the Secretary Home, all the orders are given from retrospective effect. If it is 9, it was given from 6. My submission would be that this order will not amount to confirmation of the order passed by the Director of CBI on 6th or any other date. In cases of different telephone, different dates, different year is there. I am making a general submission that until there is any whisper either in this order or any other order they place before this order. So, whatever interception that was done as per the authorization of the director, that cannot be used at all in view of the provisions of section 419 because that has not been complied with. Now, I'll come next to, this is one aspect. Para 2 of the order says, clause 2, that it contains reason for such direction and a copy of such orders will be forwarded to the concerned review committee. Nothing has been placed on record. My lord, an argument may come that no, we are not, the order was passed by the Secretary Home. Order was passed by the Secretary Home and CBI has nothing to do with. that will not suffice, because the subsequent clauses, which already pointed out to your my lord, I'll come directly then to now para para clause 14 at page 53. And para 14 is very important. The service provider shall put in a place adequate and effective internal checks to ensure that unauthorized interception of message does not take place and extreme secrecy is maintained, and utmost care and precaution is taken in the matter of interception of message as it affects privacy of citizens. This is very important. It varies my fundamental right under Article 21. Now, clause 16, a review committee has been constituted. But I am not reading that. Then next is very important. Clause 17. The review committee shall meet at least once in 2 months and record its finding. Page 53 I am reading. And record its finding whether the direction issued and Malad got it. Whether the direction issued under Subrule 1 are in accordance with the provisions of subsection 2 of section 5.2 of the said Act. When the review committee is of the opinion that the directions are not in accordance with the provisions referred to above, it may set aside the directions and orders for destruction of the copies of intercepted message or class of message. Or the consequences, that is very important. Record pertaining to such direction for interception or intercepted message shall be destroyed by the relevant competent authority and the authorized security and law enforcement agency every 6 months, unless these are or likely to be required for functional requirement. The functional requirement, the word is very important. Not for purpose of prosecuting somebody. Their functional requirement was therefore for their internal requirement. But for their functioning, whatever is required, they can store. Otherwise, they have to destroy it within 6 months. और कुछ है कंटेक्ट दिखाना है ना और कुछ दिखाना है बोलो तो है ही है ओरिजिन से हम लोग बोले ही है ना in this regard, I would like to give certain decisions. फोटो का नुकसान हो सकती है लाइन दे दो पहले हुक्म चंद दो Yeah. Lord, I'm referring to first the decision in Hukumchand Samlal versus Bureau of India. Lord, here the scope of section 5 was gone into, and basically in this case 5.1 was in issue. Now what I'm trying to, the wording of 5.1 and 5.2 as regards the public emergency or in the interest of public safety, well, these are the basic requirement in 5.1 also. Now, I'll be reading paragraph certain lines were disconnected and all that. It was in that context that was challenged by the telephone, general manager telephone, by making certain orders in 1972. The one of the order was that the Delhi administration has certified that while order dated so the public emergency exists, and that in continuation of Satta, or the Satta business was going on. Now in the election period also Satta is going on, that who will get how much and all that. Seats, BJP will get 400 or not, or just 370. So all these things Satta is going on. The continuation of Satta at the premises of Coronation Hotel, Fatehpuri through a telephone is prejudicial to the public interest. The undersigned in exercise of the power conferred under Rule 422 of the Telegraph Rules hereby ordered to disconnect the telephones and non-exchange lines mentioned in the list supplied by Delhi administration copy attached. Well, I am not reading the entire. My lord, in page 131, paragraph 13, Section 5.1, if properly construed, does not confer unguided and unbided power on the central government, state government, especially authorized officer to take possession of any telegraph. Firstly, the occurrence of public emergency is the sine qua non for the exercise of the power under this section. So my submission would be that to exercise power under section 5 to the sine qua non is the public emergency or the public safety. As a preliminary step to exercise the further jurisdiction under this section, the government or the authority concerned must record its satisfaction as to the existence of such an emergency. Further, the existence of the emergency which is prerequisite for the exercise of power under this section must be public emergency and not any other kind of emergency. The emphasis on that very important, very important. The expression public emergency has not been defined in the statute, but contours broadly delineating its scope and features are discernible from the section which has to be read as a whole. In subsection 1, the phrase occurrence of public emergency is connected with and is immediately followed by the phrase or in the interest of public safety. These two phrases appears to take color from each other. In the first part of subsection 2, what will kindly see 5.2. In the first part of subsection 2, those two phrases again occur in association with each other, and the context further clarifies with amplification that public emergency within the contemplation of this section is in which raises problem concerning the interest of the public safety, the sovereignty and integrity of India, the security of the state, friendly relation with foreign states or public order, or the prevention of incitement to the commission of an offence. The last is the prevention of incitement to the commission of offence. It relates back to the other requirement which has been stated earlier, because it cannot be in the context of a criminal case or an offence committed by anything. It says incitement of the commission to an offence. Sedition and all that, those laws, those will come into the purview of that. It is in the context of these matters that the appropriate authority has to form an opinion with regard to the occurrence of a public emergency with a view of taking further action under this section. Economic emergency is not one those matters expressly mentioned in this statute. Mere economic emergency, as the High Court calls it, may not be necessarily amount to public emergency and justify action under this section unless it raises problem related to the matter indicated in this section. So, public emergency, public safety has to be read in the context of the other provisions of section 5(2) that has been derived. It cannot be in connection with a case where a person is trying to give some bribe to somebody to obtain some favor in his favor. They are trying that incitement of an offence will come within purview, that Prevention of Corruption Act will come within the purview of that, and they can do it. That's what your Lordship will kindly see in the order also, either of the director or of the Secretary Home. 76, 2 STC, 128. Huh? Now, paragraph 15 and paragraph 15 I will read. Rule 422 empowers the division of engineer to disconnect any subscriber in the event of any emergency with or without notice. The existence of any emergency to the satisfaction of the division appears to be necessary prerequisite to the exercise of power under this rule. It is significant that while section 5 speaks of the occurrence of public emergency, satisfaction with regard to the existence of which is to be recorded by appropriate authority mentioned in that text. So that has to be recorded. Rule 42 purports to empower the division engineer to take action thereunder in the event of an emergency. The scope of word emergency in Rule 20 is apparently wider than the expression public emergency used in it. It follows that a satisfaction is not required. Now, para 18. Para 18, basically, the principles was derived from the Privy Council's decision of 1936. It is well settled that where a power is required to be exercised by a certain authority in a certain way, it should be exercised in that manner or not at all, and all other modes or performance are necessarily forbidden. It is all the more necessary to observe, this is important, it is all the more necessary to observe this rule where power is of a drastic nature and its exercise is a mode other than the one provided will be violative of fundamental principles of natural justice. Now, in the present case, if the telephone of the appellants were to be disconnected on the ground of misuse, then they had to give an consonance with the principles of necessity, opportunity of these are not required. Now, the next case is PUCL.
Already discussed.
Already shown. I'll just refer to the paragraph, nothing, I'll not read that. There are 17, 18, 19, 20, 21 are these paragraphs. Then we will rest in para 27, 28. In para 27, Hukum Chand has been referred. But I am not reading. I am just referring to my Lord. Lord, listen to the
In PUCL, which para? PUCL, which para you are referring?
Paragraph 27, 28.
27, 28. 20 is referred by other
27 basically the I have read the Hukum Chand case that has been referred.
28 is 28 is referred by
no, it's true. 28.
Yes.
I'm just reading one line. 13. Para 27, it is quoted from the Hukum Chand, skipping. Then para 28, I'll read only. Act permits the interception of message in accordance with the provisions of subsection occurrence of any public emergency or in case of are the sign for the application of. Unless a public emergency has occurred or the interest of public safety demands, the authorities have no jurisdiction to exercise the power under this section. Public emergency would mean the prevailing of a sudden condition or state of affairs affecting the people at large, calling for immediate action. The expression public safety means the state or condition of freedom from danger or risk from the people at large. Both the expression has been not defined here. That's what I am. But I am not reading. Then para 29. Once these two conditions are satisfied, then the other 5 conditions, either or, that has to be satisfied before passing an order.
Your page 10.
Yeah. Now,
The last term that the council is putting us in the case has not just been fire. In the case of Punjab Kamla. That is again 5-1-0.
Yes, 5-2.
In fact, that has been dealt with in Hukum Chand also. I have read 5-2 because he said that 5-1, though those conditions are not there, in 5-2 those conditions are specifically mentioned regarding the security of state and other things.
Yes.
So,
There are 5 conditions.
yes, 5-2. So it has to be in consonance with that, not, it cannot be, just without anything, there will be a public emergency and all that. In a situation here, where the allegation is that, I have already read again and again, it is not a case of public emergency or public safety. Other condition has not been satisfied. The next step in 5-2. Now, para 32, only just one line I'll just show. The second press commission, para 32, your Lordship just noted down, I am reading only one line. Taking of telephone is a serious invasion of privacy. Now, the PUCL case that has been approved by in Kutuswamy. That was 2017 10 SCC 1. I am not reading because 5-2 was not dealt with because it simply approved the PUCL case. So that decision has been approved in the largest bench decision of Kutuswamy. Now, there are 3 decisions of 3 different high courts on this question, and one they have cited in their affidavit of Sanjay Bhandari, that is from Delhi, Madras High Court. They are trying to rely on that decision. In that decision, it says that no, they have complied with the 5-2 and all that, so there is no infirmity and all that in Sanjay Bhandari. Now, Binit Kumar, already read. Binit Kumar says that no, it is violative and all that. Rajasthan High Court, shown another decision probably nobody has shown though mention has been made with regard to KDL Nargis versus Government of India. That is a decision from Andhra Pradesh High Court. नागाश्री KLD नागाश्री सेकंड वाला भी देना पड़ेगा इसको भी है. So in that decision, in para 9, Hukum Chand was discussed. I am not reading the entire. Para 9, Hukum Chand was discussed. If you lordship find there. Then para 10, PUCL was discussed. Relevant paragraph it's paragraph 22. So not, the facts has been narrated and all that, then other decisions has been then carried out. However, a mere perusal of the impugn order extract above shows that the order was there. Order of interception only in occurrence. However, a mere perusal of the impugn order extracted shows that the same did not refer to the occurrence of public emergency against the public safety interests which are prerequisite for the exercise of power under section 5(2) of the Act. But this was reported in AR 2007, Andhra Pradesh 102. As a matter of fact, except repeating all the 5 situations mentioned in section 2 of the section 5, verbatim, no specific reason which warranted interception of the petitioner's mobile telephone was mentioned. The state fact itself shows that the impugn order was passed mechanically without application of mind to the facts and circumstances of the case in hand. Hence, on the face of it, the impugn order is not in compliance with the mandatory requirement of section 2 of section 5. Not only the satisfaction of the authority as to the occurrence of public emergency or existence of public safety interest is absent, but even the satisfaction expressed with regard to the other situations enumerated in subsection 5 of the Act does not stand the legal scrutiny. That apart, the specific allegations made by the petitioner with regard to non-compliance of the subsequent procedure required to be followed under Rule 419A could not be contradicted by the respondents, except reiterating the object and purport of 5(2) of the Act and the guidance issued by the Supreme Court in so and so. The counter affidavit filed on behalf of the respondents are silent as to the procedure laid down on 4192 must place the compliance thereof. On the other hand, the material furnished to this court in slip cover by the learned counsel appearing for the Government of India shows that the review committee constituted under Rule 419A met on ISNA for the purpose of review of the order authorized interception tapping of telephones of the Act. In minute book of the meeting, it was recorded that consolidated statement of orders authorizing interception passed by the Home Secretary since 23C was placed before the committee, and the committee has decided to hold another meeting during which the following information was desired and placed. However, no materials has been placed before this court to show that the review committee has met subsequently for this said purpose, and the information required by the committee was made available by the committee. Thus, it is clear that no finding is required under sub-rule 9 of the Rule 419 of the rule was recorded by the review committee. Admittedly, by ISNA on which the date review met more than a year has left from the date of impugn order, there is absolutely no material to show that the state order was forwarded to the review committee within 7 days. It is also relevant to note that the order of interception remained in force for a maximum of 180 days, and apparently by date of the review committee meet on ISNA, the state period has elapsed. Viewed from any angle, the impugn order dated so and so held to be in accordance with provisions so and so cannot be held. Therefore, the same being expressly is able to be set aside. And this they went in appeal in this case. The CBA. Here to further. This matter was carried on in a division bench in writ appeal, and the recent judgment of 2023, decided on July 20, 2023. May I Lordship kindly come to para 12. Para 12. The what I'm just trying to show that whatever the allegation in that particular case regarding giving bribe and all that, in tenor of the above paragraph does not affect any one of the contingencies under section 5(2) of the Act. On other hand, the allegation in the charge sheet pertains to receipt of illegal gratification, which read as under. I'm not reading. Another crucial para 14. Another crucial aspect which needs to be taken note is that as per section 2, it is obligatory and mandatory on the part of the competent authority to record the regions in order to interception. But the case in hand, the reality remains the respondent in the petition failed to record any regions in the order of interception, accepting the language employed in the respective provisions of law, and by any stage of imagination, the same cannot be considered as strict compliance of the mandatory requirement of recording the regions. Any amount of explanation in the form of counter-affidavit or sustaining the impugned order of interception is on the no consequences and renders no assistance to the case. So anything they say in the affidavit, giving some regions and all that will not suffice. The region has to be there itself. Then para 20, 21, 22, 23. Since the provision of the enactment and the rules enables the authorities to look into the privacy of the citizens in deviation, relaxation of Article 20 of the Constitution, strict and scrupulous adherence to the provisions of law and rules is mandatory, and any deviation to the state rules would undoubtedly render the action unsuccessful. In the concerned opinion of the court, the order of interception passed by the central government having regard to the regions recorded supra cannot sustain in the eye of law. In fact, when Leonard single judge by assigning cogent and convincing reason allowed the restriction. So one of the single bench decision was approved by this court. Now, one thing I would like to point out to the appeal in para 25. They say that the appeal and this court does not incline to meddle with the article order passed by the Leonard single. Appeals were dismissed accordingly. Now, in this case, Vinit Kumar and all other has been also discussed. I will just pinpoint two aspects of the matter. That the Vinit Kumar decision is also pending before the Honorable Supreme. They are relying on the decision of Sanjay Bhandari that decided by Madras High Court. That is also pending before the Honorable. I have yesterday been given the entire, the matter is fixed on 9/7/2024. No, I'm not reading the entire because from beginning on the upside down. The Lordship will last find 9/7/2000. Tentatively case may be listed on, likely to be listed on. Sanjay Bhandari versus the Secretary of the Government of India. The matter was admitted.
Tentatively listed on 9/7.
Huh?
It will be tentatively listed on 9/7.
9th, I'm not sure that it will be listed on all that, but that I am showing. That I am showing. Then, so far is the other case is Vinit Kumar. Also, both are taken together.
Yes, that I will submit.
Criminal history, 8,008 of
P11. P11.
Criminal
Criminal entry 3.
P118 oblique 2022. Judgment dated 17 January 2022. And all the single cause what the detailed judgment this is not under the case. Most likely it is not challenge of I cannot get it. I do not know my brother Bhavani will vote it out. The single passing has taken into consideration Gary as well as all other judgments. Actually, they emphasize that if you are not doing the tapping lawfully, neither can you rely on it or can you hold it. That means destruction is fine. So, if Delhi High Court is operating, then they are bound. If one High Court is acting against them, and that they are not contesting. So, Article 14 will come into operation. They cannot do it. In the case of the single cause, they will destroy. In the case of the transformer, they will not.
Not as far as
Okay, it will remain part-heard then.
I'll just clarify one thing. Now, let it be
No
part
option.
the last decision which I have shown, that Nagastri's decision, but I have tried to find out whether that has also gone to Supreme Court, but I could not find out anything.
Nagastri, na? Nagastri one.
Nagastri. There are two other cases, those are pending before the Apex Court. And I have heard that this Rajasthan High Court has also been admitted by the Supreme Court recently, but I couldn't trace out the exact case. All the matters are pending, and if the CBI could have waited for some time, and if we get the Supreme Court decisions finally, that will be ultimately binding on everybody.
Yes.
Because 9/7 is not far.
Not so far.
Not far.
Yes, that. It is 9/7 is Monday. No, 9/7. 8. Acha.
In our case, then your lordship would like to say.
But can it be taken on 24th of this month?
24, maybe it will be a holiday.
Day after tomorrow, lordship. Not possible.
No, not possible in a sense. It's a different thing. But the question is that most probably we have already discussed this matter because it's the Madhav Devor Tithi of Madhav Devana. So maybe there will be holiday by our High Court also.
Oh, achha.
So
It was restricted.
38th lordship, other my counsel for the respondent is appearing in another case, lordship. This will be clash, lordship.
it will be difficult. Not 38, it will be difficult.
38th, let it be on 27th and what? 27th.
27, I cannot say.
No, lordship. It is not a small IA. They have filed a writ petition, lordship. They have filed a writ petition on 27, lordship. Let it be on 27. Almost everything, everyone has made their submission, lordship. Only my reply will be there only.
After that,
Obviously, in your presence, it will be hard. 27, Mr. Holloway, it may not be possible. 27 order. So matters have been fixed, I think. Some old matters are also fixed. 27 and 30. I don't know, 20.
Then let it
Can
be
be
on-
possible? It will be possible on 30th? 30th you are here. Now, Mr. Hello, you have some difficulty on 30?
Yeah, on 30 I can lodge it because their case has been picked on 31st, I think. Their case has been picked on 31st, not 30th. So,
Mr. Srivastaba's case is on 31st or 30th?
Or 30th.
30.
Consent has not been taken. I don't know how. You have not taken any consent. Date was fixed.
We just moved to IT. That came. Malagandi has directed to this one. He was sitting on 7.
Then let it be on 30th. Let it be on 30th. IA they have filed lawsuit with regard to stay, I think. That IA. Yes.
IA to Kali move kara hai.
30th.
It's more like
Yes.
Rumah ke kane jana. They live to visit.
Not 30th.
Partner 30th. 30. That's what I'm saying. Today also the other matters have already been left over. No, that's why
38 is a hearing day basically.
30.
30 is hearing day Thursday.
Thursday, if it is Thursday, then maybe it may be possible. If
That's what
I may ask the registry also to list number some matter.
Yes.
Or it can be taken at 2 or like that.
Yes.
Two will I don't think.
At 2 so that we also get little respect.
Replies.
Anyway,
Yeah.
we leave to my lord, we'll be there on 30th to argue the matter.
Today you were going to return to Chhat, Didi?
If necessary,
No, it's just not necessary. If we get something from Supreme Court also, it could have been better, but let the matter be heard first.
That's what I have pinpointed and I got the information yesterday. My lord will decide. We have
Let us hear the matter.
we have brought in
At that time, what will happen?
we have brought to the notice of my lord. It is my lord's decision.
In that case, we should go by their conduct. They are not conducting.
Okay, information. Mr. Hello, I think Delhi order have been there.
lawsuit that is not within my knowledge. That is not within my knowledge. I'll have to say.
We could not find anything. Police can tell whether they are affected or they are still